Well, hello, hello. How's everybody doing today? Today we're going to talk about something really different. I don't know if you're aware of this case or not. Let me fix my chair. I'm not in the middle. All right. Um, what's wrong with the screen? It's kind of weird. How Let's fix this camera a little bit. I guess that's okay. It's still off. Okay. Today we're going to talk about my. It's too close. We're going to talk about a case under the name of William Thomas Ziegler Jr. This is a fascinating story because this man, hear me out, has been on death row for 5 decades in Florida. I know what you're thinking. How in the hell does somebody be on death row for 50 years in Florida? That's an interesting question, and we're going to get right to it. But first, we're going to read our fair use disclosure. This broadcast, hey there, Sprinkle. Hey, I sent you a link. I sent you the link, but here I'll give it to you again this way. Hang on a minute. We'll get it this way. Copy. Okay, paste. There, I'll send it to you that way. Did you try the one I sent you? Or did I send you the wrong? Let me pull it up again this way, and then we'll start over. We'll just start over. It's okay. Jeez. Oh, okay. Here we go. Let me pull it up. I can't pull it up that way. Damn it. Okay. Oh boy. I can't pull it up from my phone because we are live. So let me see. I think I sent it to you. Let me see. Was it yesterday before we started talking about everything else? I think it's this one. I think it is this one. Hang on a minute. See if I can close it. See if it'll let me do it first. Okay, come on. Okay. I don't know which one that is. How would I know that? Browser for studio. Okay, I can't pull it up on my phone because I can't be on two StreamYards at the same time. So, I sent you I think it's the one that I sent you at Um, I sent a couple of them yesterday. What time was this? Was it at 1:25 yesterday? I think I sent it to you. Check your phone for 1:25 yesterday. Now I'm going to go ahead and finish reading this fair use disclosure while we wait on Sprinkle Donut to come on up so we can get at it, talk about our case. This broadcast contains commentary, criticism, analysis, and discussion of publicly available information, including court documents and media reports and third-party content. All materials used in this stream are presented under protections of fair use as outlined in Section 107 of the U.S. Copyright Act. This includes transformative use for purposes such as reporting, teaching, scholarship, education, and public interest commentary. All individuals discussed in this stream are presumed innocent unless proven guilty in a court of law. Hang on a minute, let me add my friend to the stage and then I'll finish reading this. Okay, I'm going to finish reading this right quick. All individuals discussed in this stream are presumed innocent unless proven guilty in a court of law. Any allegations mentioned are allegations, not established facts, unless explicitly stated otherwise. This channel does not assert guilt, does not create or fabricate evidence, and does not present speculation as fact. This channel does not tolerate false accusations of misrepresentation or defamatory claims directed at me or my content. Any claims suggesting that I created, altered, or manipulated evidence, images, or documents are categorically false. All materials shown are sourced from publicly available records and clearly identified as third-party sources. So there you go. Your discretion is advised. This is true crime topics, and sometimes what we talk about are explicit or sensitive materials. There you go. That is the case. Hey, Sprinkle Dunn, how are you doing? Haven't seen you in a few days.
I'm good. How are you?
I'm good, good, good. So I want to get that out of the way. So isn't this a strange case? I'm
It
telling you,
is. It
how
is.
happened. Hang on. Let me put this back in here. So pull up the rest of this. Okay. I have a lot of the documents. I mean, because he's appealed. He's had many appeals. He's had many different things that went on in this case. And finally, I think it was March 7th of this year. I think a judge shut it all down. But he still to this time does not have a death date. Now, 50 years.
I
I
know.
don't understand. Oh, okay.
That's unheard of. It's unheard of.
I mean, I don't know if there's any other state where somebody has been on death row for that long. Florida may have the winner here. So strange. So, let me look. Are you looking it up to see if you can find anything?
I can. Let me just
Yeah,
pop
look it
open
up.
my
Look it up and
laptop.
see if. Yeah, my phone is almost dead. I don't have my plug in here, but I want to know if any other state has anybody on death row longer than 50 years. I think it's
I
fascinating.
I think I read that he's the longest person on death row.
In the U.S.
It
Okay.
didn't specifically say U.S., but I'm gonna put that in the search bar and see what comes
Okay.
up.
Cool. That'd be great.
I
In the
gotta turn everything
meantime,
on.
all right. While you're looking at that, here's what we're going to do. So today we're looking at one of the longest, most controversial death row cases in American history. A case that has survived 5 decades, outlived judges, prosecutors, governors, and entire eras of forensic science. A case where the evidence has been questioned, re-questioned, and scientifically dismantled. Yet the man at the center still remains on death row. This is the story of William Thomas, Tommy Ziegler, who has now spent 50 years fighting the same conviction. I got a lot of questions, as I'm sure a lot of people have a lot of questions. And here's another little tidbit. He actually
He is
passed a polygraph.
he is he is the longest.
Okay, all right. So
The second
that is,
is someone named Raymond Riles. He's been on death row since 76 as
wow.
well.
Well, we might have to actually do a show on him too.
It says Raymond
Remind me of
Riles,
that.
though he had, following decades of appeals regarding his severe mental illness, his sentence was commuted to life in 2021. But he
Okay,
but he had been on since 1976.
that's incredible.
So 1976 to 2021.
That is incredible.
Mm-hmm.
I mean, it's almost unbelievable because you think in your mind, how can a system allow this to happen? Has nobody ever tried to write to a president and maybe do something about this? I mean, or to the Department of Justice or anybody, reach out to anybody to try to get this man help. You either go through with it or you commute his sentence to life. Because at this point, he is a very old man. I believe he's 70 years old, is what I think I remember.
He's
Um,
80. He's 80.
he's 80 years old.
He's
What is the
80.
point?
Yes.
Right. I mean,
He's
what is the
80.
point now? There's no point in giving him a death date. You might as well commute his sentence. All right. So let's
Yeah,
study
there's
that.
a few. There's actually, from what I pulled up, I picked up the top 20.
Uh huh.
Well, he's number one, and then Raymond Riles, the guy I just spoke of,
Uh huh.
he was 45 years on death row. Somebody named James Hitchcock, he was
Uh
50
huh.
years before he was executed.
Right.
Um, One man named Richard Jordan, he was executed last year. He had been on for 50 years. A man named
Um,
Gary Alvord, he spent 40 years before he died of natural causes. And Tommy Ziegler, he's still on the list.
that it's just fascinating to me how this. I know I keep saying that word because I'm just so shocked as to
Mm-hmm.
how this can happen. But I mean, as we're saying, if he's 80 years old, there is absolutely no point in even giving him a death warrant date. They need to just go ahead, commute it now, and let it be that. But here's what. First, we're going to hear. I'm going to talk about how this happened, when it happened, the who, what, why, and how. Then we're going to go back and see where the judge made a determination. I believe it was March 7th of this year. I tried to find oral arguments for this case, but because it's so old, there are no archived oral arguments for me to pull up. Because they're not going to do oral arguments on a case more than once, really. I mean, that's just an opportunity they get one time at that, and then they have to file all different kinds of different appeals. So let's go back to how this actually started. On Christmas Eve in 1975. Now I remember that year. I was 15 years old. Yes, I am old. I was 15 years old. I remember it. The night that everything changed. On Christmas Eve, inside his own furniture store in Winter Garden, Florida, 4 people lost their lives. His wife Eunice, his in-laws Perry and Virginia Edwards, and a customer named Charlie Mays. A customer. He's going in there, going to buy some furniture. He never leaves the store except in a box. That's horrible. So instead of him taking furniture out in a box, they're taking him out in the box. Okay, that's not funny, but it kind of is, but not funny. Anyway, I don't know. I'm kind of in a silly joking mood today. Anyway, so he also shot himself, bleeding, barely alive. Was this a I'm going to take myself out and the whole family? Or was this I need some money, I've got a little insurance, so I'm going to take out my family? Was it something else? Was it a robbery gone wrong? What happened here? We don't know, but we're going to find out. From the very beginning, the crime scene was just chaos. Blood was everywhere. Their bodies were staged, weapons scattered, and a narrative that never quite added up. Now, if this man is barely alive, how is he staging the scene? Does that make any sense? There's a lot of big red flags in this case. I will say that out front. So, um, there's no way that if he was barely alive, he could have done all of these things before the cops got there. Police immediately locked onto one theory, and one theory only, that Tommy Ziegler killed them all. Whoops, it was him. That's what they decided, and that's what they went with. We all know that, I mean, many years ago, it was different. Crime scenes were different. The whole thing was different because we did not have the ability to test the DNA, to do the scientific things we do now. So there's a lot of, well, this is what it looked like to me type, type evidence, or type detectives taking notes and statements, whatever. And it's a lot of, that's what it looked like to me. A lot of times we've also heard of defendants giving false statements, or claiming responsibility for something they didn't even do, thinking that they're just going to walk out of there and that's the end of it, not realizing that everything they say truly is used against them. Miranda rights are no joke. They really mean those. So that is what happened there. But the physical evidence, even in 1975, it did not match that story. And as forensic science evolved, the gaps only widened. So they're still like perplexed and said, now wait a minute, how did this happen? Because there's also some questionable DNA situations here. I know, it's wild. Now, the prosecution always has their story, and the defense always has their story, but then there's always what is exactly the truth, right? So that's what we have to put together from all the different stories told. So the prosecutors claim that Ziegler orchestrated a massacre to collect insurance money, but there's a problem with that story. No financial motive was ever proven. No gunshot, hear me out, there was no gunshot residue on Ziegler. Now, I tell you, he was barely alive. There's no gunpowder on him, no residue, and no blood splatter on him. There's nothing on him. So how did he? And he's barely alive. So how did he do all of this? Are you sure he's not a victim? No blood splatter consistent with him beating or shooting multiple victims. And the state's star witness, a man with credibility issues who changed his story repeatedly. Okay. Even the judge who sentenced Ziegler to death overrode the jury, which had recommended life, not execution. That override would be illegal today. It absolutely would be. You cannot do that. You have to go with, in a jury trial, what the jury has given them. You have to do that. Now, think about all the things I just said. But yet, he did it. Just ask the cops. He did it. The next thing that happened in this case, and this was 20 years afterwards, they had to battle the DNA questions. 20 years of no from the state before they would actually test the DNA. To me, it almost sounds like they're railroading this guy into getting a conviction because they're not allowing his defense to test the DNA, etc. Right? So as DNA technology advanced, Ziegler's attorneys started begging for testing. Florida fought it for decades. When testing finally happened, the results were explosive. The blood on Ziegler's shirt belonged to Charlie Mays, not Eunice, contradicting the state's theory. And then Mays' blood was found in locations that supported Ziegler's version of events, not the prosecution's. No physical evidence ever tied Ziegler to the murders, yet courts repeatedly ruled that new evidence is not enough. Now, that throws up a lot of red flags. Was Mr. Mays coming in there to rob the store? Is that what happened? or take the money on Christmas Eve because he needed to go buy things for his family. Who knows? Because it could have really been, it could have been that that's how Ziegler and his family got shot. And then did Ziegler grab the gun and shoot Mr. Mays? What happened here? Things just don't add up. Then we're going to go back. We're going to go back to year 2024 through 2026. This is the final legal push that happens. So, in recent years, Ziegler's team has pushed for one last chance, a full evidentiary hearing or a new trial. But Florida courts have continued to shut the door, even as judges acknowledge the case is deeply troubling. Forensic experts state that the theory is scientifically impossible, and I tend to agree with that. And Ziegler is now in his late 70s and remains on death row after 50 years. This is no longer just a legal case. It's a test of whether the justice system can admit it may have been wrong. And now we're going to talk about why this case matters, because it does matter. There is no reason for somebody to sit on death row for 50 years. Who?
Well, I feel like we have to look at these cases as if this was our family member.
Right.
We want it to be fair. We want it
Yeah.
to we want the right person to be convicted of the crime. Period. Just convicting somebody of a crime doesn't bring justice for the victims.
No, it doesn't.
And
I mean,
and
look
I
at the
just
yogurt shop murders.
oh yeah. I
That's
mean,
a perfect example right there.
it just doesn't, it's
Oh,
just
shit,
not
shit, shit.
true justice. It's just not. And
No, it's
why would
not.
you, if I try to put myself in the position of the victims' families, how would I feel knowing that I didn't 100% know that the person that was being convicted was the one who killed my family member? I don't think that I could sit with that because it would always sit in the back of my head. What if? What
That's
if
right.
that person's still
What if?
out there? What if this isn't the right guy? Did I really get
I
justice? And
mean,
I think I mean, of course I've never been in that position,
right.
but I feel like I would just be like, no, this just no, I can't live with this decision.
Well, okay.
Even
Remember that case? Remember
go
the
ahead.
case where the lady was great, and then she finally realized that she picked the wrong person in the
Hmm.
lineup,
Hmm.
and then she started fighting for him to get him out of prison.
Yes, but I don't remember the name of it.
Yeah, I don't remember it either, but I'm like, but because nobody lived except Mr. Ziegler here in this story, and there was nobody else in the store to help tell the story, he has nobody to help him except science, except let's relook at this scientifically. Let's look at all the evidence. Let's get new eyes to look at it. That's all he has. So it's as if, and this case it matters because it terrifies people. It terrifies the families to think, what? And you're right. What if this was my family? The
Okay,
Ziegler case,
this is the name of it. Anthony Broadwater was
yeah,
the name of the
okay,
guy who, and her name was Alice Siebold. She was
okay,
raped as an 18-year-old, mistakenly identified Broadwater in a police lineup. He served 16 years in prison, but was fully
damn,
exonerated in 21 when DNA evidence and discredited forensic methods prompted prosecutors to vacate his conviction. Upon his exoneration, Siebold issued a public apology to Broadwater and deeply advocated for him, stating she was forever sorry for the life he was robbed of.
yeah, he was robbed. I mean,
Hmm.
how old was he when this event happened? When he was arrested?
Let's see. It doesn't say, but let me see if I can find it.
But I mean, 16 years in jail for something you did not do. And the only reason why he got out was because the victim decided I picked the wrong man. I think I picked the wrong man.
Um, let's see, it's loading. He was 20 when he was wrongfully
Okay,
accused. He
20
was
years Alzheimer's.
21. He was 21 when he entered the New York State prison system. He was 38 when he was released in 1999. At
God.
61, he was formally exonerated. At 61, he was released at 38, but at
Uh-huh.
61, he was formally exonerated and received a public apology from her in 2021.
Okay, think about that story. He's the wrong person, and he's 38. He gets out of prison, and he's 38 years old. He's got this felony hanging over him, right? So this causes big problems for jobs, for a life, to be able to buy a house, all these different things, because he was in a situation where he could not get a quality job. He did not get the education he needed to get a quality job. So finally, at 61, when he gets fully exonerated, that's when you can actually file to get paid because you were wrongfully incarcerated. But he's 61 at that time.
New York agreed to pay him $5.5 million 3 years ago.
Okay, so 3 years ago, how old was he at 3 years ago?
Well, 61, 2021, he was 61,
Right,
62.
okay. Okay, so at 65 years old, we're going to say, well, no, 3 years ago he got the money, so maybe
Yeah,
61 is
this
it.
this
But still, I
started at
mean,
64. Hmm.
64 years old, and they're going to give him $5 million. But he was still robbed of a quality life. Yes, you can do a lot of things with that money, and luckily, that money is not taxable. Okay, it's not
Well,
income, so it's not taxable.
and you have to wonder, what did he do between 38 and
Yeah,
61? What is that?
you're right.
That's 23 years. What did he do to try to make a living for those 23 years, as marked as he was?
I don't
Was he
know. Hey,
able to
KJ,
was he
man.
able to was he able to make a
Yeah,
living? Was he not? Um,
I
I
don't
mean,
think. I mean,
that's
hey,
just
I
it's
don't
just
know.
appalling that something like that can happen in the United States of America.
It is. KJ Mack has joined us today. She caught a live. Yay! Thank
Yay,
you. Thank you for
welcome.
coming in. We appreciate that. I know that sometimes our topics are not very interesting to other people, but I find this one pretty interesting because 50 years on death row, he's an 80-year-old man. Anyway, so that, yes, but why this case matters is because it is terrifying. Ziegler's case is the perfect storm of everything that can go wrong going wrong. It was a rushed investigation, and we've talked about this before because people are like, I want this crime uh, settled. I want to know who did it. I want whoever's responsible to go to jail. I want this taken care of now, 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 because we are a very now society. The judge is overriding a jury, which was, you cannot do that now. It's illegal. Yeah. Happy to catch one. I tried it when I get home from work, but yeah, I know the time zone can be tricky. I get it. Thank you, KJ. We appreciate that. I'm so glad you're in here. Don't you live in down under? Aren't you over there in Australia? Are you in? Or I think you are. I could be wrong, but I think you're in Australia. But anyway, yeah, the time zones are an issue. But yeah, it was like the perfect storm. And yeah, a judge took it upon himself to not give the person. No, she's in Europe. Okay, in Europe, it's still the time zones are a problem. Thank you, though. I hope I'm so glad to see you. But the judge decided he didn't like what the jury gave the guy, so he overrode it and made his own sentence, which now you cannot do that. It's illegal now. And then there was withheld evidence. Now we know withholding evidence is a Brady violation, but back then, see, there was not the Brady violations. This had never been tested, and there was not a new rule done. So there he is, still over here. Then there was a refusal to allow modern testing, which I don't understand now. How can you refuse to test the DNA when you have the technology to do so that could show somebody did not do what they were accused of doing? And the man who has maintained his innocence for half of a century? Yeah. If the system can keep someone on death row for 50 years, despite modern science contradicting the original theory, what does that say about the death penalty? I mean, we
Well,
know
and
that the death
yeah,
penalty
I
is
mean, and
final.
it's talks here about the Florida and federal appellate courts have repeatedly denied Ziegler relief on the grounds of a Brady violation. The courts ruled that the alleged suppressed evidence was either not strictly material, meaning it wouldn't have altered the jury's final verdict, or that the claims were procedurally barred because they were raised too long after the initial trial. But why should that matter? How
Yeah.
do they know it wouldn't have swayed their verdict?
What is too long when you are trying to prove your innocence? What is too long? Oh, should they just give up after 20 years? Oh well, is that what they're saying to us? How is that fair? Think about that. I do have a show that I'm planning on doing, and I'm working on it now about the death penalty and the biases of it because it is a little biased, right? It's sad. Yeah. I am not a death penalty supporter, even though my sense of justice sometimes wants this. I just feel it's not in alignment with my stand. Yeah, KJ Maxx, I get that. And some cases don't should not get the death penalty. Now, in some cases, maybe yes. I mean, I've been a proponent of it before, but then I've started looking around when I started planning on doing the show about the biases of the death penalty, and I found such a discrepancy between the races and how they get treated, and I thought to myself, this is not fair. So a lot of people are going to be like, "Oh my God, she's gotten too soft." No, you got to look at the whole situation. You can't just look at each crime. It is the whole situation and what's going on death row in these cases where people are given death. It's you can't change it. Once it's done, it's done. And there have been innocent people put to death because they're rushed to the damn chair or they're rushed to the lethal injection. So I do want to get that show together, and we'll be bringing that pretty soon. But I'm trying to get through the month of May here, and in June I've got a few things planned for some people that are on death row. And my question is, will they get a stay? And did their crime deserve the death penalty anyway? So,
I don't know.
there's fairness. Go ahead.
Where the death penalty comes into play, I feel like you in a lot of ways, but then
Mhm.
on my other side of it, I feel like if you kill a child and you are proven 100% guilty, you should get the death penalty and across the board in every state. Period.
Well, let's talk about the guy who killed all five of his children. Remember that guy? We just did that case not too long ago. I think he deserved
Yeah.
the death penalty.
Oh,
But here's the
absolutely.
thing.
I feel like
I mean,
Letitia deserved the death
your
penalty.
how do
You
you take
know?
out your own children? That hurts. I mean, I don't understand how somebody can stand there with a gun or anything. Or this particular guy strangled all five of his children. The ones that his hands would not fit around their neck, he just went and got his belt and did it. Yeah, that's what he did. It is horrific, and that kind of a that is when I feel like, okay, well, there's something wrong with this guy. He can't ever live
Oh,
amongst us.
yeah.
And how is he going to do in prison, right? I mean, something's very wrong there. But, another part about this is the state willing to correct itself? And I think the answer in this case is no. Now, I have all of his appeals pulled up over here, and there's many of them. Let me share the screen with you here. It is, the guy has had, and he's tried and tried and tried to get justice for himself. Here we go. So look at this right here. Okay, I'm going to go back to the top so y'all can see. Okay, so this is I think it's in reverse order of like the 2026, like it goes from, oh, no, yeah. See, here we go. This was 427 to 26. Let's read this right quick. Okay, yep, let's go ahead and view it. Come on, slow. Now, this is the last thing. This is the last thing that's happened on this case. Is this right here? Not that. Damn it. This is the last thing that happened. So on 427 of 2026, the Supreme Court of Florida, in this case, notice of appearance, please take notice that John Houston Pope appears as one of the attorneys for the appellant, William Thomas Ziegler, in the instant case. And it's the reason why it's instant because, he's been 50 years. The undersigned is admitted to practice in this court and requests that all papers served in this case be delivered and served addressed to him. Okay, so and there's the certificate of service. But before that happened, I'm just going to go down the line here.
How
Um,
many people do you think are on death row in the United States? Take a guess.
I'm going to say 350.
2,100.
Whoa! That's more than I thought. Good God.
2,100 are facing death sentences across the United
That's
States.
huge. Yeah,
That's
that's huge.
huge.
2,100. And
2,100.
the Catholic diocese actually gets involved in every one of these cases, every death case. They start fighting for every one of these people. We read about that the other day in the case that we did. So I thought that was kind of interesting too. Why is this thing
There's
circling like that?
690. There's 690 in California, 323 in Florida, and 199 in Texas.
Damn. Well, at the next official, okay, why does it look like that? Let's see. Let me share the right screen. Look what it's doing. Let me share this other screen with y'all. The next official death case is going to be out of Alabama, and it's a guy named Richard Lee. And there it is. His name is Richard Lee. So that is the next one that we're going to be watching to see if he gets a stay or not. And I've already got that planned for June the 4th. So let's read what's going on here. I want to know exactly what this is. So he's taking notice that he's going to be the attorney. And then there's this motion for substantive. Okay, good. It is with us. Here we go. So comes now the defendant William Thomas Ziegler and respectfully moves to leave to file the below sir reply in opposition to the motion for stay filed by the Florida Attorney General. On December 22nd, the AG requested leave to file the reply brief. The motion was granted on December 27, 2022. Now, this is 4 years. Good cause for sir reply exists because the AG sought entirely different relief in its reply brief than the AG sought in her original motion. In its emergency motion, this was an emergency motion. Okay, the AG sought a stay of the order entered by the trial court on December 19, 2022. AG's motion number 1, in its reply, the AG asked for the entirely different and particularly drastic relief for this court to order Ziegler to immediately direct the return of that evidence to the clerk of the court and the sheriff's office. And reply as 1, the AG may not alter its request for relief in reply without affording Ziegler the opportunity to respond to the AG's new request for relief. As a matter of due process and fundamental fairness, by being granted the right to submit the below. Let's see, what are they asking for? In its reply, the AG makes an extraordinary and illogical new request. What? That this court orders Ziegler to immediately direct the return of the evidence to the clerk of the court and the sheriff's office to preserve the integrity of the evidence. Okay, so apparently his attorney had evidence. This is what's going on. But the AG does not offer a shred of evidence that the testing will threaten the integrity of the evidence. Okay. To the contrary, the trial court's order went to great lengths to specify the manner of handling the evidence, specifically to ensure that the evidence is not compromised and that the chain of custody is preserved. Indeed, nothing could jeopardize the integrity of the evidence more than forcing the ISO certified lab currently holding its evidence in custody to repackage the 47-year-old items, ship them back to 2 separate locations, and have the items reinventoried, all on a potentially temporary basis. Indeed, if the court ultimately rejects the AG's appeal, as it should, then each one of those steps would need to be repeated again, jeopardizing the evidence even further. The AG's request obviously is not motivated by any concern for the protection of the evidence. It is a naked attempt to interfere with the testing of critical evidence and to prevent the defendant from proving his innocence. Wow, okay. This laboratory currently is in receipt of evidence, in this case, both ISO certified and used by both the state and the defendant. It is the same lab that is conducting DNA testing in Mr. Surishi's case. Okay, that's another one. I guess that's another death penalty case that conducted the testing that led to the exoneration of Robert Du Bois. Oh, okay. Now, and that conducted testing to identify the true perpetrators of the crimes for which Mr. Du Bois was convicted on behalf of the state. The AG cannot credibly maintain the allowing of FACL, a lab that does work for the defendants and the state, to hold and test the evidence pursuant to joint motions filed by both the defendant and the state. It poses a greater risk to the integrity of the evidence than forcing it to be repackaged, reshipped, and then unpacked potentially 2 more times. nor does AG advance any, let alone arguments for why the court should entertain an appeal from the AG over the objections of the state's attorney's office or permit the AG to interfere with the SAO's decision to authorize testing. The AG repeats the very same arguments in its reply that the AG raised and lost in Cereces. Contrary to its assertions, the AG does not represent the state in this case. It merely represents itself and says as much in its notice of appeal, which states that it is on behalf of the AG, not the state. The state is represented by the state's attorney's office, which both authorized and jointly requested the release of the evidence for DNA testing. As such, the AG's appeal and motion for emergency relief are both frivolous and should not be rewarded with this drastic relief. This issue of whether the AG acts for the state in cases such as this was squarely presented, fully briefed, and unanimously decided in Cereces, and the AG offers no evidence of argument to contrary, even in its reply. Wherefore, the defendant, William Thomas Sigler Jr., respectfully asks the court to deny the Attorney General's motion to file a reply or, in alternative, grant Sigler's motion to file a reply. Okay, so that is that. Now, we're going to go back and see what happened next. You see, it's almost like, here we go, back over here, close that one. It's almost like they're trying to stop him from proving his innocence. I don't understand that. Okay, here's a miscellaneous document. Let's see what it is. All right, let's see. I want to get down to the actual appeal itself. Well, we do have the very first appeal. I don't think it was the very first one. I think it was the second one, actually. Remember the document I sent you yesterday from 1990? Let's see. Here's a mandatory review. Let's see. Get down over here. These are all from 2000. Okay, 427. Motion. Okay, let's read this motion from 427. All right. Because nothing, okay, so look, the last time before 2026 was 2016 when anything happened in this case. So he'd been in there 40 years trying to get out. Now we've got another 10 years. I'm telling you, this is wild. Okay, let's see. Verified motion for admission to appear. What?
No, go ahead. Go ahead.
Oh, I need to share the screen. Duh. Sorry, I forgot to share the screen so you can see exactly what I'm looking at. So, thank you. It is interesting. Let's see. Comes now Elizabeth B. Cochran. Movement herein and respectfully represents the following. I reside in Tarrytown, New York, and I am not a resident of the state of Florida. I am an attorney and a member of the law firm of Hogan Loveless U.S. LLP with offices at 390 Madison Avenue, New York, New York. I was retained personally as a member of the above-named law firm in 1986 by Mr. William Thomas Sigler Jr. to provide legal representation in the above-style matter, now pending before this court. I am an active member in good standing and currently eligible to practice law. There's her bar number. There's no disciplinary proceedings. Within the past 5 years, I have not been subject to any disciplinary proceedings. I've never been subject to suspension. I've never been subject to disbarment. And I either by resignation, withdrawal, or otherwise never terminated or attempt to terminate Hogan Loveless as an attorney in order to avoid administrative, disciplinary, or disbarment suspensions. Let's go down and see why she's given this information. All right. Okay. We're going to go to the next thing that happened here because that's just like she's just saying, hey, here's my affidavit. Let's see. What about this next one? That was 5-4. That was the mandatory review. Let's look at the 5-4. I want to get down to one of these appeals. What I want to do is go in. You know how in some of these appeals, when you're actually reading these things, what actually happened and what was described in the courtroom is in the appeal. It's kind of interesting. Yeah. This is interesting. It happens to be a Catholic. Oh, yeah. 15. Yeah. Yeah. You know, when I found out that the Catholic, I don't remember what the name of this. I just know it's ran by Catholic something something. When I read about that and I understood that they go in and they go for every single death penalty case trying to help the people, I thought it was like, you know, there's no other religion that would even attempt to do that. So this motion to appear by David R. Okay, so that's a new attorney. I want to get down to this appeal. So let's go over here. Okay, those are reviews. We know what those are. Okay. Review, miscellaneous documents. So orders, motions, let's see, miscellaneous. We'll just go on down. 1221. Let's go to the next page. I know it's a long case. Look, it just goes on and on. I want to go down to the very first appeal. Yeah, because that's where we're going to find out exactly what happened here. Okay, there we go. Are we down to it yet? Damn. There's not 1,000 pages on this guy. There just can't be. Oh, no, there's not. Okay, I see it has all the Zieglers in the same group together. Okay, got it, got it. All right, here we go. Just a minute. I have to go back over here. I think it starts right here. That's Joseph. Let's go over here. Now we're going to go back one. Okay. William. Is this William? No, that's Joseph. Here we go. Notice of appearance, order recorded filing, non-evidentiary capital order record, order record. It's going to be somewhere over here. Notice of cross. Okay, I'm going to read this right here. Now, this is pretty old, and I think it's going to be pretty big, I think. I don't know. Let's see. Come on.
Just a tidbit of information, 231 prisoners have been executed in the last 10 years in the United States. 2025 was the highest of 47.
Where is his actual appeal? That's what I'm looking for, is the, okay, mandatory review. I'm looking for his appeal. Remember that document that I sent you on our phones? I can't actually read it from my phone, so that's why I'm trying to pull it up over here so we can actually read it, because that's where you're going to find out everything that actually happened in this case. So, I don't want to see the reviews. Where is the brief? Let's see, order. I want to see a brief. Letter, order. Response. Let's go back one more page. Let's see. This is crazy. I mean, because the brief should be right here. This is everything that's ever happened in this case. Disposition rehearing. How many pages is that? Okay. Let's look at this one right quick. Okay. Notice what it says right here. 1220. Okay, you can't see that. Sorry. Let me share this. I got to share. Oh, yeah, you can see it. Good. It says right here, whoops, motion stay proceedings below 12/20/2022. So we're going to look at this. Okay, let's see what it says. I don't know why they did not grant him a stay then. At that point, he was still a really old man. It's just ridiculous. Okay, here we go. Emergency motion to stay the trial court's hearings. The state of Florida hereby moves for a stay of the order entered in the trial court in December 19th of 2022. That order authorizes the clerk of the court to release evidence in its long final capital murder case for DNA testing, but does not purport to have made the findings required by Florida Rule of Criminal Procedures 3.853 and Section 925.11. Instead, over the objection of the Attorney General, the trial court permitted the testing pursuant to an agreement between the defendant and the state's attorney's office in the Ninth Judicial Circuit. As explained below, a stay is warranted to prevent the state's appeal of that order from becoming moot. As timing is of the essence, the trial court has already denied a stay of its order and is short of a stay. The circuit court clerk may release the evidence any day and without warning to the Attorney General. Now here's the background. Let me see if it says anything different than what we already know. In 1976, William Ziegler was convicted of first-degree murders of Eunice, his wife, Charlie Mays, a friend, as well as second-degree murders of his in-laws. Ziegler admitted that he was at the scene of the crime, and there is no dispute that his blood, as well as blood of the 4 victims, was present at the crime scene. As this court has previously remarked, in order to accept Ziegler's theory of this case, the jury would have had to disbelieve at least 3 witnesses who testified at the trial. After previous rounds of post-conviction DNA testing, which failed to exonerate Ziegler on 2 occasions, this court rejected his renewed request for testing, concluding that even if the DNA results comported with the scenario most favorable to Ziegler, he still would not have been able to show that the evidence would have probably produced an acquittal. Boy. And that Ziegler has failed to demonstrate how the results of the additional DNA testing would give rise to a reasonable probability of an acquittal or a lesser sentence. Yesterday, on December 19, 2022, the trial court issued an order purporting to grant a joint stipulation between the Ninth Judicial Circuit Office and the state attorney and Ziegler's, authorizing the clerk of the court to release this evidence for additional post-conviction DNA testing. It did so over the objections of the state's co-counsel, the Office of the Attorney General. Though post-conviction DNA testing is governed by the Florida Rule of Criminal Procedures 3.853 and Section 925.11, Florida State, which set out various requirements before the testing, shall be ordered that the trial court did not make the findings necessitated by the rule. Instead, the trial court merely cited the so-called joint stipulation. Subsequently, the trial court denied the state's motion to stay its order pending appellate review in this court. The state, acting through the Attorney General, has now appealed the DNA testing order. Okay, an appeal may be taken by adversely affected party within 30 days from the date that the order on the motion is rendered. Reasons for granting the stay. In deciding whether to grant a stay pending appeal, an appellate court considers the moving party's likelihood of success on the merits and the likelihood of harm should the stay not be granted. Okay, both factors support a stay in this case. To begin, a stay is necessary to prevent the state's appeal from becoming moot, to ensure the finality, and to bar the release of evidence to a third-party laboratory for an unauthorized testing. Release of this evidence in this case could moot the state's appeal and might occur at any moment because the trial court has denied the state's request to pause the effects of its own order. Release of the forensic evidence in this case also harms the state, the public, and the victims of Ziegler's crimes, all whom are entitled to finality. Okay, well, so is he. Risk of an erroneous deprivation of appellee's purported liberty interest is given the substantial evidence of guilt, with the state's need to ensure closure for the victims and the survivors. The circuit court's order frustrates the import's principle by allowing Ziegler to continue litigating his conviction and death sentence outside the confines permitted by this court and legislature in Rule 3.853 and Section 925.11. And though Rule 3.853 safeguards the integrity of forensic evidence by requiring that the DNA testing shall be ordered to be conducted by FDLE or its designee, unless movement shows good cause, okay, the order below authorizes release of the evidence to a non-FDLE laboratory. Ziegler, on the other hand, will suffer no harm if the court grants the requested stay. Ziegler is incarcerated on death row and not under an active death warrant. There is no hearing scheduled for which the requested evidence is relevant. Ziegler has repeatedly requested DNA testing in the past, and even when he did obtain testing, he was unable to rebut the substantial evidence of guilt presented at trial, including multiple eyewitnesses that proved he committed 4 murders. He has been consistently unable to show how further testing would exonerate him. The state is also likely to prevail on the merits in its appeal. Contrary to the trial court's conclusions, the state attorney had no authority to unilaterally waive the requirements for testing under Rule 3.853 and Section 925.11. Over the Attorney General's express objections, the legislature has made the Attorney General co-counsel of record alongside the state attorney in capital collateral proceedings. The state attorney thus may not unilaterally bind the state in capital post-conviction matters over the objections of the state's official co-designated to work on those matters. The conclusion comports with basic principles of agency law, under which co-agents like the Attorney General and the state attorney may act jointly, not unilaterally. In cases where one has not delegated its authority to the other, the joint stipulation therefore did not authorize the circuit court's order. Number 12, absent of valid stipulation, the order conflicts the Rule 3.853 and the underlying statute of Rule 3.853 permits DNA testing only where the defendant establishes a reasonable probability that movement would have been acquitted or would have received a lesser sentence if the DNA evidence had been admitted at trial. Okay, now I'm going to finish reading this and then don't let me forget what we're going to talk about next. We're going to go back to this DNA was not admitted at trial. That's important. So here we go. But the appellee did not even attempt to make that showing, nor could he at this court has twice found Ziegler has failed to demonstrate how the results of additional DNA testing would give rise to a reasonable probability of acquittal or lesser sentence. Number 13, testing thus does little more than delay justice yet again to the victim's family and to the public in this long final case. On the top of that, The testing ordered by the circuit court would risk this corruption of evidence because the order allows testing by a private lab instead of a Florida Department of Law Enforcement, as Rule 3.853 requires. Number 14, the state acknowledges its unsuccessful appeal in State versus Series. However, the defendant raised several procedural thresholds and arguments that are unavailable to Ziegler in this proceeding, and which may have formed the basis for the court's unelaborated per curiam affirmances and of the trial court's DNA testing order, State versus Series. The ruling is not binding on the merits. Okay, I'm going to skip a lot of these cases that he's stating because there's a lot of, it doesn't matter. The court should, hang on guys, the court should therefore issue a stay here so that it can resolve the importance of merits questions presented by this appeal and questions which have already begun to reoccur. Conclusion, the testing respectfully requests that the state respectfully requests that the court stay the trial court's DNA testing order until it can rule on the merits of the state's appeal, and given that the evidence at issue may be released at any point, potentially mooting the state's appeal, and given the impending holidays, this court may wish to consider imposing an administrative stay of the trial court's order pending briefing and decision on this motion. Okay, so there we go. So now let's go back and talk about this for a minute. Now I understand. Let me turn that off. I understand that. Hang on. Come on, cancel. I understand that when this trial happened, that you could not test DNA because this was over 50 years ago, right? So they never tested the DNA, and what they're saying here is they have tested it a couple of times, but it did not change the results, right? Oh, you're off to bed? Okay, see you later, KJ. Have a good afternoon. Or I'm sorry, have a good sleep. We'll see you next time. Thanks again. Anyway, so apparently, they did not test the DNA, and then when they did test the DNA, what happened? Well, it looks as if the DNA shows that it was him. But I don't, okay, we got to figure this out. How could that happen? Hang on a minute. Let me look at this here. Okay. Zeigler. What was the result? Hang on. There's a lot to this. And that might be the reason why he has never been let out, you know? Okay. Okay, put this in here. All right. So that is the big question here. What they're saying is, well, what's the point what is the point in letting him test it? It's not going to change he's not going to change his death sentence. But here's the thing I really want to know. I want to know, okay, short answer. What did the DNA testing show? The DNA results undermined the prosecution's theory and supported Ziegler's version of events. But see, it's saying in those documents that that's not what happened. The blood on Ziegler's shirt was not his wife's, it was Charlie May's blood, right? May's blood was found in the places that matched Ziegler's account, and no DNA or blood evidence tied Ziegler to the beating or shooting of any of the victims. The state's theory of bloodbath involving Ziegler was scientifically impossible based on the DNA patterns. See why this is not making any sense at all? What the hell? I'm not on at this stage. What happened here? Uh-oh. Where are you at there? I don't see us both. Let me change it. There we are. Okay. There. All right. So how can this be? And then let's talk about Ziegler's shirt. The prosecution claimed that he beat his wife Eunice at close range, meaning her blood should have been all over him. Now you got to remember, when this is happening, he was near death himself. This matches Ziegler's claim that Mays attacked him and they struggled. This is one of the most damaging results for the state. The blood splatter. Modern forensics analysis showed the blood on Ziegler's clothing was low velocity transfer and not high velocity splatter. High velocity splatter would be expected if he shot or beat multiple victims. This supports the defense arguments that Ziegler was a victim of an attack, not the perpetrator. Okay, Mays' blood in key locations. DNA showed that Mays' blood on clothing, on surfaces, and in areas consistent with Ziegler's account of being ambushed. This contradicts the state's theory that Mays was merely a set-up victim. Number 4, no DNA tying Ziegler to the murders. Despite 4 victims and violent scenes, no DNA evidence places Ziegler as the killer. No blood from any victim was found on him in any way consistent with the prosecution's story. For a supposed hands-on quadruple murder, that's extraordinary. And I agree, it is extraordinary. How can that happen? Then there's the gun evidence. The state claims Ziegler he just executed everyone with multiple guns. But there was no DNA or fingerprints tied to him, to the weapons, that the way the state described it. Some of the guns had no usable prints at all, which is inconsistent with the prosecution's version of chaotic struggles. So number 6, the state's response. Florida has repeatedly argued the DNA results do not conclusively prove innocence. The conviction should stand because the jury could still have believed the original theory. But this science directly contradicts the original theory. See, there's so many red flags here. I don't understand it. I don't understand how they have not
Well,
overturned this.
but to say it could, but it also could not. So how can you use
Exactly.
the word could and you cannot use the word could not in the same sentence? That is just doesn't seem right to me. I'm sorry. It just doesn't.
Right. I don't understand, you know.
Because how are you going to know how the jury is going to react to anything that is presented? Nobody knows that. That is not something that you can tell. You can't say, here's the evidence. I think the jury's going to say this.
Right.
No, you can't do that. So how can you say it could not sway or change the outcome? That's the point of having a jury. We can't as we No judge can determine which way a jury's going to go, because there's been many cases, I'm sure, where a judge thought a jury was going to go one way and they ended up going the other way. You can't predict human nature
That's right. You can't.
with
And
100% certainty. You can't.
let me see if I can pull this other thing up over here. File
I
May
mean,
the
fairness.
29th.
This judicial system is set up to be what, fair, quote fair and impartial.
Right?
This doesn't sound very fair and impartial to me.
No, it doesn't. It sounds to me like they are doing everything they can to not admit that they may have made a mistake. And I always question, did Texas get it wrong? Did Florida get it wrong? Because this is ridiculous. It's absolutely ridiculous. Now, let me see if I can find this over here. Enter.
I mean, it's
I'm
very
trying to
easy
find that
to,
document, see.
yeah, it's very easy to look at any case and look, well, not any case, but some cases, and look at the evidence, and one person argue one way and the other person argue another way. Of course,
Right.
that's how it's set up, prosecution and defense. Obviously, that's the way the system is meant to be played out.
Okay.
But there is that line down the middle where fairness has to come into play and the evidence has to match what is being argued. So if the evidence doesn't match the argument that they're innocent, obviously the jury's going to go with guilty. But if the evidence matches that he is not guilty, then the jury's going to go that way. That's the way the system is set up to work. Not for the judge to say, well, I don't think the jury's going to say that, so forget about it.
I mean, that's just
You know what I mean?
ludicrous. It is. It's ludicrous to think that you can determine. Well, okay, this judge even changed the sentence that the jury actually said. He said he didn't like it, so he made it a different one. How is that possible? I
And
mean, it's not possible today, but
how is
yeah.
yeah, you couldn't do it today, but I mean, come on.
Okay, I'm
If
gonna pull
that's
this
not
document up.
biased, I don't did he have a criminal record prior to this?
That's a question I don't know. So let me see if I can actually pull this document up that we have that I sent you yesterday. Okay, it's the
I'm gonna Google
ACIS.
it and see what I can find.
Okay. Okay, it's called the ACIS is where these documents came from, and they're really old. Like I think they were actually microfilmed, to be honest with you, and that might be why it's so hard to get this. But let's see case search. If I can put just the number in there. Here's the case number. Um, Actually, I think we can put the tab number here. Okay, here we go. Let's put it in here like this. 7-4.
Let me see what pulls up.
Damn it, I can't see.
He had absolutely no prior record, absolutely no criminal record prior to the 1976 murder convictions.
That's crazy.
Before the Christmas Eve 1975 murders, he was an upstanding local businessman and had never been arrested.
That's crazy. I mean,
So that
well,
makes it even more like, what the hell?
oh boy. Okay, I don't know
Because
why I
they
can't
try
pull
to
this stuff
pin
over
things
here.
on people that have, like Broadnax, how much stuff they tried to pin on him because of his previous record and all of his criminal activity. They try to bring that into play. But this one, you can't even use that as an excuse. He was a
Right?
businessman.
He had a furniture store.
Hmm.
I see, and I thought to myself, really, um, okay, why can't I pull this up like this? Okay, let me see if it'll let me pull it from this one. Okay, well, let's do this. Oh, stop it.
Let's see if he
Pull
owed
this
any
up.
money.
Right. I mean, well, he owned a furniture store, so you know.
Well, and
Let me
I
see
mean,
if
I know
this is going to pull it up.
they're trying to play the
Monthly
whole life insurance
expense.
policy. People take out life insurance policies on their family all the time.
They sure do.
It just says no, Tommy Ziegler did not owe any money at the time of the 1975 Christmas Eve murders. In fact, his defense heavily emphasized that he had no financial liabilities to establish a motive for the crime. Instead, the financial dynamic in the case was quite the opposite. The Ziegler family was highly prosperous with personal and commercial business assets surpassing $1 million in 1975. He successfully managed a family owned W.T. Ziegler furniture store and owned several local apartment buildings. Despite his wealth, prosecutors argued his motive was greed rather than debt, that he allegedly killed his wife to collect $500,000 from two active life insurance policies. The defense countered that the policies were standard estate planning measures recommended by his attorney to cover future estate taxes.
See,
Who
I mean,
actually owned the money? Charlie Mays, one of the four victims killed inside the furniture store, was Charlie Mays, a local laborer and customer. According to investigators and Ziegler's own statements, Mays was known to gamble and owed Ziegler money. Ziegler maintained that Mays came to the store as part of a robbery crew to wipe out the debt and steal from the business.
see, I always thought in this case that Mays actually came into the store to steal. That's what I thought. I've always thought that. I
That's what
don't
it
believe that
says.
this guy just started
That's what
killing
it
people for
says.
no reason. So
I wonder
why
how
is
much he owed. Let's see. How
yeah? I wonder how much. Yeah, how
much
much did he owe him, and how is
did
this possible?
he owe? Well, if he gambled, it could be quite a lot of money.
Right? Or was he renting from Mr. Ziegler? Was that it?
No, he think he was just a friend and worked for him.
Okay.
Well, investigative files and
Oh,
news
well, I
archives
can't pull this
confirm that
up.
Mays was a regular customer who owed Ziegler money. The specific dollar figure was not central focus of the trial testimony. The debt was primarily used by the defense as circumstantial evidence to explain why Mays was at the furniture store after hours on Christmas Eve, posting I think it says positioning, they spelled it wrong. Positioning
Okay.
that he came to rob the store to clear his financial obligations.
Hmm. Well, I don't know why I can't pull this up today. It will not let me go back to this ACIS and pull these filings. It says,
Let's see if he
it's
owed
done.
any loan sharks.
Okay. Okay, let's see. This is really pissing me off. I mean, I don't know why I can't pull this back up. And oh, you know what I'm gonna do? I'm gonna send it to myself. Hello, stupid. You can pull it up this way. Sometimes I don't know how I manage in a
It
day's
says
time.
it is unclear if Mays specifically owned money to outside loan sharks. Ziegler maintained that Mays was known to gamble and was recruited by the true perpetrators to participate in the staged robbery to wipe out his debts.
Hmm. Okay. All right. We'll pull this up this way. I just emailed it to myself because I was not able to get it through the court system. It just wouldn't
Ziegler
let me. I'm like, come on, man, this is stupid.
Ziegler alleged that a highly lucrative illegal loan sharking rig was operating in Winter Garden, Florida. The operation reportedly targeted Black migrant workers, charging them predatory interest rates as high as 520% per year to buy groceries on credit. Ziegler claimed that
Wow.
several members of the local Winter Garden police force were actively involved in or protecting this illegal ring. Prior to the murders, Ziegler had been gathering information to shut down these illegal activities. The defense argued that the corrupt individuals framed him for the Christmas Eve murders to protect the loan sharking enterprise and
Ooh.
silence his investigations.
You know what? See, that could be possible. It absolutely could be possible. You know? Okay,
If
let
he
me
was
get
an
this thing
upstanding
here.
citizen and this guy was his friend and his guy had gotten wrapped up with these people, I mean, it makes sense.
Yeah,
I
it
mean,
does
that's
to
a
me too.
pretty,
You've seen
I
that
mean,
happen
for some,
before.
yeah, and for somebody that has no criminal record to bring up something like that, uh, that to me sounds very logical and very warranted.
Yeah, it sounds very fishy, doesn't it? Okay, now I've got this over here. I'm going to turn that off. Let me come back over to where we are. Now I'm going to share the screen. We're going to be able to look at this now because now this is pretty interesting. This is the original appeal, and this is what I was looking for. I was like, why can't I pull it up? All right, so let's share the screen. Got it over here. Because, again, when we read these appeals, we find all kinds of information that you don't really know because we're not in a courtroom and we don't have a transcript. So this was filed on May 29th, 1990, and it's William Thomas Ziegler Jr. So let's go on down here. Okay. Answer brief of appellee. Okay. Here we go. Right. Statement of the case and facts. Here we go. Now make sure y'all can see the same thing I can see. Okay, you do. All right, good. Now, this court made detailed findings of the facts and its opinion on direct appeal, Ziegler versus State. Those findings were that on Christmas Eve, December 24th, 1975, Ziegler's wife, okay, we know that, let's move down, in Winter Garden, Florida. In addition, Charles Mays was beaten and shot to death at the same location. Now, how in the world is Mr. Ziegler barely alive, but he can do all that? Time of death
Yeah.
were all estimated by the medical examiner as within 1 hour of 8 p.m. Ziegler was also shot through the abdomen. He didn't shoot himself, did he? The state's
Well, it
theory
says here, yeah, well, I'm sorry, go ahead. I keep interrupting you.
The state's theory of the case was summarized as follows. Edward William had known Ziegler and his family for a number of years. William testified that in June of 1975, Ziegler inquired of him about obtaining a hot gun. Williams then went to Frank Smith's home and arranged for Smith to purchase two RG revolvers. The revolvers were delivered to Ziegler. Also, during the latter part of 1975, Ziegler purchased a large amount of insurance on units. Mays and his wife came to Ziegler's furniture store during the morning of December 24th, and Mays agreed to meet Ziegler around 7:30 p.m. The store was closed at 6:25 p.m. Mays left his home around 6:30 p.m. He went to the Oakland Beer Joint and saw a friend, Felton Thomas, who accompanied Mays to the Ziegler's furniture store. Now, see, hang on a minute, let me see. All right, this is why I love to read this part because you see, these are the real details that we don't know. They're coming out right here. So some of this Ziegler may well have done this. He might have, based on what we're seeing here. Okay, so we'll keep going. All right. I wish I could find footage of the trial, but that's never going to happen because it's so old. According to the
Right.
state's theory, Ziegler had two appointments on Christmas Eve, one with Mays and one with Edward Williams. Prior to these appointments, he took his wife to the store and in some manner arranged for his parents-in-law to go there. He killed his wife Eunice quickly and for her unexpectedly, since she was found with her hand in her coat pocket, shot from behind. Because of the location of her body, Virginia was probably trying to hide among the furniture. Perry probably surprised Ziegler with his probably. See, they keep using the word probably, trying to hide him. Okay, so Ziegler with his strength and stamina as they struggled for some time. After Ziegler subdued Perry and rendered him harmless, Ziegler shot him. Considering the fact that the bullet penetrated Virginia's hand, it was likely that she was huddled in a protective position and she was executed. Trigger warning, these are some very disgusting things we're going to talk about, but this is what happened. Ziegler then left the store, returning to meet with Mays, who had arrived there at about 7:30. He was probably surprised to see another man, Felton Thomas, with Mays. He took Thomas and Mays to an orange grove to try out the guns. The purpose of the trip was to get the. Now, wait a minute. Wait a minute. Now, think about what's going on here. We're going to go back a moment. According to the state's theory, he had two appointments on Christmas Eve, right? One with Mays and one with Edwards. They go to the store, and the parents were there, and Virginia and Eunice was there, right? So they're saying that he shot them and then left the store? No. Wait a minute.
Yeah, that doesn't make sense.
Something's weird because he didn't have the guns yet, did he? All right.
I had read that he had that meeting prior to the crime.
Okay.
That the meeting for the guns was prior to that, in
Yeah.
order to get everybody's quote unquote fingerprints onto the weapon, but that it was days before.
Yeah.
So I think that's a typo.
Well, they're not supposed to make mistakes in transcripts, you know.
Yeah.
Okay.
Yeah.
We're going to go back over here. Because of the location of her body, Virginia was probably trying to hide among the furniture. Perry probably surprised Ziegler, who is Perry, with his strength and stamina. Okay, the father-in-law, with his struggle for some time. After Ziegler subdued Perry and rendered him harmless, Ziegler shot him. Considering the fact that the bullet penetrated Virginia's hand, it was likely she was huddled in a protective position. Ziegler then left the store. Remember, okay, so he shot her and he shot three people, then left the store. That's what it's saying. Returning to meet with Mays, who had arrived there about 7:30. He was probably surprised to see another man, Felton Thomas, with Mays. He took Thomas and Mays to an orange grove to try the guns. The purpose of the trip was to get the two to handle a firearm or the weapons in the bag. Okay. They're trying to say in their theory that Ziegler was getting those two guys to be his fall guy because their fingerprints were going to be all over the gun.
Right.
Okay. From the grove,
But according to what I'm reading, they're saying in June, Ziegler reportedly met with this handyman and Edward Williams to ask him how to obtain a hot gun. And that the meeting with the guns occurred on or before December 24th. So this was prior to.
He get the guns. Listen. William testified that in June 1975, Ziegler inquired to him about obtaining a hot gun. So that's right. That's what it said. Then it also said that he murdered these people on December the 24th in 1975. So that's right. That's what happened there. Okay. Now.
It says here he acquired the guns used in the crime 6 months prior to the murder in June 1975.
That's what this says right here in the transcript.
Mm-hmm.
Okay. So now let's go back where we were. So this is wild. So let's get away. So he's surprised to see. Okay, so they go to this orange grove. There's something about this going to this orange grove to provide evidence. Okay, so the purpose of the trip was to get the two to handle and fire the weapons in the bag. From the grove, he returned to the store, but was unsuccessful in getting Mays or Thomas to provide evidence of a break-in. He did, however, get Thomas to cut off the lights in the store. Okay, so he's getting these two set up. The three returned to Ziegler's home. Ziegler got out, went to the garage, and came back and took a box of some kind to Mays and told him to reload the gun. They returned to the store. Ziegler could not persuade Thomas to enter the store, so Thomas lived. Otherwise, he'd be gone too, right? When Thomas disappeared, Ziegler returned to his home and picked up Edward Williams. Ziegler had killed Mays. Whoa, when did he kill Mays? Come on now. Ziegler could not persuade Thomas to enter the store, so Thomas lived. When Thomas disappeared, Ziegler returned to his home and picked up Edward Williams. Ziegler had killed Mays. When? See, it doesn't talk about when he killed Mays. When? When did he kill Mays? Because he was found in the store as well. But so we'll go back right, and this is kind of wild. He took Thomas and Mays to the orange grove. They shot the guns. The purpose of that trip was to get the two to handle and fire the weapons in the bag. From the Grove, he returned to the store, but was unsuccessful in getting Mays or Thomas to provide evidence of a break-in. He did, however, get Thomas to cut off the lights in the store. The three returned to Ziegler's home. Ziegler got out, went to the garage, came back and took a box of some kind to Mays and told him to reload the gun. Now, this is where it doesn't make any sense. They returned to the store. Ziegler could not persuade Thomas to enter the store, so Thomas lived. When Thomas disappeared, Ziegler returned to his home and picked up Edward Williams. Ziegler had killed Mays. When? See, there's no timeline of when he killed Mays. How did that happen?
Yeah.
Where's
yeah.
the story? Ziegler was successful in getting Williams partially inside the back hallway. Ziegler put a gun to Williams' chest and pulled the trigger 3 times, but the gun did not fire. Williams said, "For God's sake, Tommy, don't kill me," and ran outside, refusing to return to the store. When he was unable to get Williams into the store, Ziegler became desperate and conceived the idea that he would appear uninvolved if he happened to be one of the victims. Accordingly, he shot himself and then called Judge Vandermeer's residence, where he knew the police officers would be. Now, why would they be at the judge's house? How does this make sense? In 1976, Ziegler was convicted of 2 counts of first-degree murder for the deaths of Eunice and Charlie Mays, and 2 counts of second-degree murder for the deaths of Perry and Virginia Edwards. The jury recommended a life imprisonment on the first-degree murder cases. The trial judge overruled the recommendation and imposed the death sentence on the 2 counts of first-degree murder. Ziegler was sentenced to life imprisonment on each of the second-degree murder counts. This court affirmed the convictions and sentences, Ziegler versus State. This was in 1982. In 1982, the governor of Florida signed a death warrant, and Ziegler's execution was scheduled for October the 22nd, 1982. After the court denied an application for a stay of execution, Ziegler filed an application for a stay of execution and petition for writ of habeas corpus in the Middle District of Florida. Because one of Ziegler's claims was identical to an issue pending in the 11th Circuit in Banks, Ford versus Strickland, the district court stayed Ziegler's execution. The district court granted a continuance for Ziegler to exhaust the state's remedies, and he filed a state habeas petition alleging 19 grounds of errors. The court remanded the state's habeas petition for a hearing on the question of possible bias by the trial judge. Bias by the trial judge. I'm still confused as how, if he was given life in prison, how was the judge able to say, hell no, we're giving him the death penalty? That's just too much. When a judge had the ability to do that, that is way too much power. That is like saying that the jury of his peers, they might as well not even have been there. Damn, that's terrible.
That's a bench trial. That's a bench trial.
Right, but he had a full-on trial with
right. I know, but that's what I'm saying. She's acting like it was a freaking bench trial. Like, I'm sorry.
This is wild. The trial judge denied relief, and his ruling was affirmed by the court in Ziegler versus State in 1985. Okay? Ziegler filed an amended petition for habeas corpus in the Middle District Court, which was dismissed on January the 3rd, 1986. A second death warrant was signed, which scheduled Ziegler's execution date for May 20th, 1985. Ziegler filed a motion to vacate in the state circuit court, which granted a stay of execution in order to hold an evidentiary hearing. The state appealed, and this court vacated the stay and denied all relief. Now, this was in 1986. Ziegler filed a habeas petition in the Middle District Court, which denied the motion for relief from judgment and for leave to file an amended petition. The district court also denied an application for a certificate of probable cause and for a stay pending appeal. The 11th Circuit Court of Appeals granted a stay of execution. This case was remanded to the district courts to consider sanctions on the lawyers. Whoa!
Hey, I just found something very, very interesting. I looked up Maurice Paul's history in court.
Who is that?
So he was the judge. The judge.
All right.
So it talks about the Tommy Ziegler case, how despite a 6-6 deadlock jury, he ordered a medical He ordered a medical sedative for a stretched out holdout juror to secure a verdict. When the jury
God.
ultimately recommended a life sentence, Paul utilized a controversial legal override to sentence Ziegler to death. Now, this is the good part. Prior to the murder, Paul, we're talking about the judge, then a state beverage control attorney, and Ziegler had testified on completely opposing sides of an unrelated case involving a black bar owner. Ziegler's side won, which the defense argued created the deep personal animosity Paul held against Ziegler during the murder trial.
Wow, if that's not
So,
shady, I don't know what is.
so how could he have actually? Wouldn't that have been a conflict of interest? Wouldn't it be a conflict of interest? How could he be a judge on his trial if he had had previous connections with him in a court hearing? How was he
What was
allowed
the
to be
previous
that
court?
judge?
What was the
Well,
previous court hearing about?
okay, prior to the murder, Paul, that's the judge. The judge's
Uh-huh,
name is Mitchell Paul.
uh-huh.
Then a state beverage control attorney and Ziegler had testified on completely opposite sides of an unrelated case involving a black bar owner. Ziegler's side won, which the defense argued created the deep personal animosity Paul, the judge, held against Ziegler during the murder trial.
Okay. Yeah, yeah.
So he had
Well,
had run-ins with him in court on a
mhm,
case. They
uh-huh.
both testified. Ziegler won. So now this was before he was a judge. He was just an attorney. And so they say that he held that against him because he beat him. Ziegler had beat him in court. So how was he allowed to be the judge? How was that
I don't
allowed?
know. That's so crazy. It is crazy. You know, well, okay, but the rules have changed substantially from now. I mean, from then to now. I mean, there's so many more rules and regs and all the things that they have to follow, right? So
It,
I
yeah, and
just,
it says Paul heavily controlled the high-profile quadruple murder trial. Ziegler's defense attorneys noted that Paul denied virtually every single one of their motions and objections.
I wonder. Here's the thing. I think a really smart attorney could have taken, if he would have had the money, could have taken this case, and he would not be on death row now because of that right there. He would have had, well, he might have gotten a new hearing. Now, I don't know if he'd be on death row, but he might have gotten a new trial based on some of the things you're telling me right there, because this just sounds like, no, there's some very wrong things here. All right. Now, that was 1986. Then Ziegler filed a habeas petition in the Middle District Court, which denied the motions for relief from judgment and for leave to file an amended petition. The District Court also denied an application for certificate of probable cause and for a stay pending appeal. The 11th Circuit Court of Appeals granted a stay of execution. This case was remanded back to the District Court to consider sanctions on the lawyers and allow Ziegler time to file an amended petition. And this was Ziegler's versus Wainwright. The petition in the district court was dismissed without prejudice when this court granted resentencing to Ziegler versus Duggar. Okay, so they dismissed that and they granted a resentencing for Ziegler versus Duggar, that's fascinating. Okay, who is Duggar? Okay, that has to be somebody in the court system, maybe an attorney, I guess. Pursuant to the petition for the state habeas corpus, the reason for remanding the case was because this court was unable to say whether the judge's decision might have been different had he realized that the non-statutory mitigating circumstances were pertinent. Resentencing was conducted in the circuit court from August 14th through the 17th of 1989. So they had a resentencing hearing. At the original penalty phase hearing in 1976, Ziegler presented testimony from Reverend Dasha that the defendant was active in church, had a good rapport with the Black community, and helped the Reverend with the Black community, served on church committees, and helped lots of people. Dr. Zimmer testified that Ziegler was a compassionate, loyal person who was not a threat to society. At the resentencing hearing in 1989, the defense the defense presented testimony from Hardy Bond, an insurance advisor who discussed the possibility of Ziegler buying insurance as early as 1970. Bond met with Ziegler various times and prepared an estate plan analysis. Ziegler later bought two insurance policies from other brokers without consulting Bond. On cross-examination, Bond testified that the estate shrinkage on the okay. On cross-examination, Bond testified that the estate shrinkage on the $500,000 life insurance of Eunice's life was only $6,000 if she died first. He also said that Ziegler seemed to be a prudent businessman, and $500,000 could have been utilized in a more advantageous manner. In order to obtain this $500,000 on Eunice's life, Ziegler was forced to take out a $250,000 policy on his own life. Even after Ziegler bought policies from other brokers, he had dinner with Bond, but did not tell him of the other policies. Theodore Van Deventer, that's a hard name, also testified for the defense. Ziegler was his client and that he discussed wills and estate planning. Ziegler did not tell Van Deventer that he had purchased $500,000 in life insurance on Eunice. Van Deventer said that Ziegler was a friend, that he had visited him in prison, and that before the murders, Ziegler was ambitious, active in his community, and helped others and was a hard worker. Dr. Wilder evaluated Ziegler on September the 1st of 1988 and believed that Ziegler was normal and had nothing in his record indicating that he would attempt to escape or hurt anyone in prison. Dr. Wilder admitted that psychiatry cannot predict who will kill. I don't agree with that. His opinion was based on Ziegler's prison records, not on the fact that he had killed 4 people. He also admitted that, okay, see, that, what kind of a statement is that? His was based on his prison records, not on the fact that he had killed 4 people. It should have been alleged to kill 4 people. All right. He also admitted that the fact Ziegler had committed 4 murders made it more likely he would have potential for other premeditated violent acts. Although, in his opinion, Ziegler was not a sociopath, Dr. Wilder admitted that antisocial personality disorders are not always apparent. He also characterized Ziegler as effeminate. Dr. Kirkland believed that Ziegler did not have an antisocial personality disorder, nor was he a danger to fellow inmates or others in prison environments. On cross-examination, he admitted that truly dangerous sociopaths are difficult to diagnose and could have spent time with Ziegler and not seen certain characteristics of personality traits. Boy. In his deposition, Dr. Kirkland stated that only a very bad man would commit the murders. He also told the court that Ziegler could repeat the performance as one who has killed before is more capable of killing again. Dr. Fisher, a correctional clinical forensic psychologist, predicted that Ziegler as having a low level of dangerousness with no violent behavior during the past 14 years of his incarceration. However, he would not have predicted that Ziegler would kill 4 people. Reverend Deshay testified that Ziegler was active in the church and helped him with the Black community. On cross-examination, the Reverend told the court that the church is full of hypocrites and a true Christian would not kill. That's a funny statement. The defense also presented testimony from friends and relatives regarding Ziegler's reputation in the community and their relationships with him. However, almost every witness acknowledged that he did not believe Ziegler committed the murders, and if he had, they did not know him at all. Pastor Biggs also testified that Ziegler, saying that the latter was cocky when he was first incarcerated, but now he was an ideal prisoner. Damn. The pastor said he was aware of the inner workings of death row and familiar with persons on death row. However, the pastor was not aware of a situation in which Ziegler had devised a plan whereby another death row prisoner would admit to the murders and exonerate himself. The state presented evidence that when Ziegler was on death row, he set up a plan with Eddie Odom in which another death row inmate, Danny Thomas, would confess to Ziegler's murders. Ziegler wrote letters telling Thomas how to give a convincing confession and relating details of the crime. Because Ziegler never obtained the money required, the plan was abandoned. Ziegler told Odom that he killed his wife because she was filing for divorce and alleging homosexual activities. A trigger warning, I'm so sorry. A defense witness, Richard Smith, also had heard rumors about Ziegler's sexuality. I'm not going to use that word, even though that's there. Okay, what is that noise? Okay. Ziegler testified about his relationship with Eddie Odom, who he called forced him to deal drugs. See, this is terrible. It's almost like a comedy. Ziegler testified about his relationship with Eddie Odom, who he claimed forced him to deal drugs in prison. Ziegler admitted to the scheme to have Thomas confess to the murders, which did not occur because he could not produce the required money. The final witness at resentencing was Robert Jones, who was the death row supervisor for two to 3 years. He said Ziegler was a model prisoner. The trial judge sentenced Ziegler to death, entering a 6-page sentencing order explaining his reasoning. The order shows that the judge read the entire transcript of the original trial, including the penalty phase, and examined any designated physical evidence. After observing the transcript and evidence supporting the guilty verdicts, he found the following aggravating circumstances. But to remember, the DNA was not presented during the original trial. So, the following aggravating circumstances: previous conviction of another capital felony. The murder of Charles Mays was to avoid lawful arrest. The murders of Charles Mays and Eunice Ziegler were committed for gain, for monetary gain. And the murder of Charles Mays was especially heinous, atrocious, and cruel. The trial judge also stated that he would have found the murders to have been committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. However, he believed this aggravating circumstances was not applicable because it was an ex post facto application. The court found that one statutory mitigating factor, no significant history of prior criminal activity. The non-statutory mitigation presented involved good, compassionate character. The judge found, hang on, did you fall out? Okay, I have to get rid of this one. All right, there, we'll go back now. This is wow. The judge found that although several friends testified as to Ziegler's good deeds and reputation, the testimony at best established his character to be no more good or compassionate than society expects of the average individual. Active participation in church and community, the judge found that none of the testimony established unusual participation. Outstanding prison records and adaptation to prison life, the judge found that Ziegler had a good prison record and appeared adapted to prison life and was an asset as an inmate. No suggestions of any propensity for future violent conduct. The judge found that the testimony revealed no propensity for spontaneous violent conduct, but found there was no evidence Ziegler would not engage in this cold and calculated violent conduct, evidenced by the murders of which he stands convicted. The court then made a specific finding that the aggravating circumstances outweighed the mitigating circumstances, and no reasonable person could conclude that the mitigating circumstances outweighed the aggravating circumstances. He rejected the jury recommendation of life and imposed a sentence of death as to both convictions. Ziegler appealed the sentence, and the state cross appealed the amended order, precluding evidence and consideration of the cold, calculated, premeditated aggravating circumstances. So, summary of the agreement. Here's the summary of the argument. Not the agreement, it's an argument. Point 1. This case was remanded for trial judge to consider non-statutory mitigating evidence and determine whether his decision to impose the death penalty would have been different had non-statutory mitigation been considered. The judge considered the mitigating evidence presented and concluded that where the 4 aggravating circumstances outweighed the mitigating circumstances, no reasonable person could recommend life imprisonment. Well, that's wild because the actual jury did give him life. The jury of his peers, the town, they gave him life. The judge decided to give him something else. That's just wild. Okay.
Well, and 2, this article that I just read talks about the Valium juror. It goes into a little bit more specifics. So that was questionable at best too, because it says when holdout juror Irma Brickell repeatedly sent notes to Judge Paul stating she was being cornered and bullied by the other jurors to vote guilty, Paul refused to see her to avoid a mistrial. Instead, without consulting the defense, he arranged for a doctor to supply her with Valium. Once heavily sedated, she gave up her holdout vote and catapulted to a guilty vote. So it very well, had that not happened, there could have been a mistrial.
Right.
So how is a judge allowed to, I would think as a juror member, you're not supposed to be, your mental state is not supposed to be altered. So how was she allowed to make a decision in an altered state after being supplied with Valium?
Hey,
How
Woman's
is that
Warrior, so good
allowed?
to see you. Hang on a minute. Woman's Warrior has came in to visit with us today. So good to
Hey,
see
woman's
her.
warrior.
Thank you. This is a weird case we're talking about. It's very interesting. If you weren't here for the beginning, you got to go back and listen to the whole thing.
Yeah,
I don't know how you.
had she not been she may not have given up and said, okay, go ahead and vote guilty. She could have been the holdout, then there would have been a mistrial. And this whole thing would be different.
How can a judge allow a juror to take medication and then go? That is. See, the whole thing just
Exactly.
seems like he was just ramrodded into this. Like
Hmm.
it's atrocious. What happened here is atrocious, to be honest with you. Okay, so we're going to go back and finish reading the summary of the argument here. Okay, the evidence presented the medication contradicted to the extent that its overall impact was negative rather than a positive one. Had the jury been aware of the contradicting testimony, they may not have recommended life. Ziegler's arguments that the jury recommendation should be given greater weight than unusual and that the trial court must enter written reasons how the jury erred are not supported by the case. Yeah, it's crazy. Okay. Lingering or residual doubt is not an appropriate non-statutory mitigating circumstance. Point number 2. The issue whether the aggravating circumstances previously affirmed by this court are supported by the evidence is procedurally barred. You're not allowed to do that. The death of Charles Mays was heinous, atrocious, and cruel, where he was shot twice and then bludgeoned to death. Now, all the time, remember though, all the time, Mr. Ziegler was barely alive. Okay? He's barely alive. This aggravating circumstance is not applied arbitrarily. The murders of Eunice Ziegler and Charles May were for pecuniary gain or monetary gain so that Ziegler could collect $500,000 worth of insurance. Charles Mace was killed to avoid arrest and cover up the earlier murders of Ziegler's wife and his in-laws. The aggravating circumstance of prior capital conviction is appropriate where a defendant commits two murders. Even if one aggravating factor were stricken, it would not change the outcome. Point number 3. The trial court considered all non-statutory evidence presented. Finding or not finding a specific mitigating circumstance is within the trial court's domain, and his ruling should not be disturbed when supported by substantial competent evidence. And point 1 on cross appeal. The trial court should have applied the aggravating factor of cold, calculated, and premeditated. This court has previously held that applying this aggravating factor to crimes which occurred before the effective date of this statutory change is not an ex post facto violation. Here's argument 1. Okay. The trial judge considered the non-statutory mitigating circumstances and imposed the death penalty where no evidence was presented which would change the original decision to impose the death penalty and where no reasonable person would recommend life imprisonment. But the jury did recommend life in prison.
Yeah, well,
This
listen
is
to
not
this.
making sense.
Listen to
Okay,
this.
yeah,
Shortly after taking the state-sanctioned medication, a heavily sedated Brickell stopped fighting. Under the influence of the tranquilizer, she finally catapulted and signed the guilty form. However, she explicitly
cancel.
stipulated to the rest of the jury that she would only do so if they agreed to recommend a sentence of life imprisonment instead of death. Years after the trial, she came forward to express her deep remorse and anger how she was treated. She stated under oath that she never believed him to be guilty, and her vote was entirely forced upon her through a combination of jury intimidation and medical sedation. Despite her sworn statements and subsequent appeals to the Florida Supreme Court, appellate judges ultimately ruled that a juror cannot legally impeach their own verdict after the trial has concluded, leaving her coerced vote locked in place. So realistically, the jury didn't even, if you look at it, it was a coerced vote. So
Yeah,
the jury really didn't even convict him on life because had that vote not been coerced, she didn't think he was guilty. It would have been a mistrial. So how can you go back with all of
well,
that and then go, okay, give him the death penalty?
What you have to do is go back and look at Florida rules of procedure back then, because in Florida, you don't have to have unanimous votes like you do in Texas. Like in Texas, all 12 has to agree. But in Florida, there's something about 9-3 or 8-4 or something. There's a weird, um, it's like the majority rules. So I
Right.
don't know what the rules were back then, but even with or without her vote, they may have still managed to give him life. See what I'm saying? But the jury did give him life. It was the judge who decided, hell no, he's getting something else. This court ordered a new sentencing proceedings before a judge alone because there was enough non-statutory mitigating evidence introduced at the penalty phase proceeding that were unable to say whether the judge's decision might have been different had he realized that the non-statutory mitigating circumstances were pertinent. Now, Ziegler versus Douglas. This court instructed that both parties should be permitted to introduce any pertinent evidence to assist the judge in sentencing decisions, observing that the original trial judge was now a federal district judge and a new judge would have to conduct the hearing. Well, he moved on up after being wrong, didn't he? The new trial judge read the entire trial transcript and heard evidence at resentencing. Then he ruled that the aggravating circumstances outweighed the mitigating circumstances and rejected the jury recommendation of life and sentenced Ziegler to death. Ziegler argues that the jury advisory sentence of 1976 should be given greater weight than usual because the original sentence and resentencing are separated by 13 years. The resentencing judge did not have the benefit of observing the witnesses at trial, which the jury observed. At the resentencing judge did not enter specific written findings that the jury had gone off the deep end. What? Okay, wait a minute. At the resentencing judge did not enter specific written findings that the jury had gone off the deep end. These issues were not raised at the trial level and are procedurally barred. So here's what I want you to do. Do me a favor, Sprinkle. Go and find out, when did they change the rules? When did they change the rules in Florida to where the judge cannot change a jury sentence?
Oh, I'm reading it right now.
Okay, good. Okay.
Let's see.
Let me.
There was there was two cases. One case was 2002, the Ring
Uh-huh.
versus Arizona decision. The Supreme Court ruled that under the Sixth Amendment, juries, not judges, must find the specific facts that make a defendant eligible for the death penalty. Hurst versus Florida decision in 2016. The U.S. Supreme Court explicitly struck down Florida's capital sentencing system. The court ruled that Florida law unconstitutionally gives judges the central role in imposing death sentences, declaring that a judge independent override violated the right to a jury trial. When Hurst versus Florida struck down the law in 2016, it triggered a wave of resentencing hearings for hundreds of Florida death row inmates. However, the Florida Supreme Court ruled that Hurst was not fully retroactive. The court decided that inmates whose death sentences were finalized prior to a specific 2002 legal threshold were not automatically entitled to new sentencing hearings.
What?
Because Ziegler's initial appeals had been exhausted decades early, he was legally barred from using the modern unconstitutional ruling to overturn Judge Paul's 1976 override.
That absolutely was not fair.
Mm-mm,
God. Okay.
mm-mm.
We'll keep going over here. All right. The trial judge entered specific written findings of facts which supported the death sentence. Section 921.1413, Florida statutes does not require the judge to point to how the jury went off the deep end in order to override their recommendations. That kind of language does not belong in in a legal document. Rather, the statute requires the judge to support his findings that the death sentence is appropriate with findings of fact based on aggravating and mitigating circumstances. This is exactly what the trial judge did. Since a jury recommendation is not accompanied by reasons, the trial judge does not know the basis for the recommendation and cannot speculate on the reasons for their recommendation. The requirement that findings be made by a judge rather than the jury does not violate the Sixth Amendment. Oh boy. The United States Supreme Court examined the Florida sentencing process in capital cases. The courts first observed that there is nothing which even requires a jury to determinations. Like the jury doesn't even have to give a determination. That's wow. Well, why even have it then? Oh my God. The court then addressed the argument that a jury, as the voice of the community, should be the final sentencer. The court explains that the community voice is heard through the legislature even if it is not given free rein, since it is the legislature who defines the rules governing imposition of the death penalty. However, the purpose of the death penalty is served when the judge is the final sentencer. The court endorsed the Florida sentencing structure, including the standard to override. A jury recommendation announced in Tedder versus State, there is nothing arbitrary or discriminatory in the jury override procedure, and the review afforded by the Florida Supreme Court assures that the death penalty is appropriate. Okay, in Spazzino, the court upheld the jury override. Ziegler points to no visible reason that the jury recommendation should be given greater weight than usual, except that the resentencing judge was unable to observe the live witnesses at the trial. Resentencing is not a retrial of the defendant's guilt or innocence. Chandler versus State and Ziegler versus Duggar, this court instructed the judge to consider non-statutory mitigating circumstances, which he did after observing the live witnesses presented. If this court had felt it was necessary for the judge to observe the witnesses from the guilt phase in order to determine whether the non-statutory mitigating circumstances were pertinent, that would have been stated in the order. Ziegler has not informed this court on how the demeanor of the live witnesses at the guilt phase would have contributed to the trial court's assessment of the aggravating and mitigating circumstances. The two defense witnesses at the 1976 penalty phase were Reverend DeShaw and Dr. Zimmer. Reverend DeShaw testified as the resentencing, and the defendant presented psychological testimony from two psychiatrists and a correctional clinical forensic psychologist. It is unclear how the judge was prejudiced by having only the cold record to analyze the strengths and the natures of the evidence of conviction, when guilt or innocence was not the issue. Okay, it's just the sentence was the issue. The review conducted by the Florida Supreme Court is from the record. The argument Ziegler makes is a residual doubt, an argument which is not recognized in Florida. The fact that the resentencing judge was on his own in weighing the credibility and the probative value of the witnesses is irrelevant. The resentencing judge properly noted that a jury recommendation of life existed. The purpose of the resentencing hearing was for the judge to consider non-statutory mitigating circumstances to determine whether his decision would have been different if he would have been the trial judge then, is what they're talking about. Ziegler urges the court to give even greater weight to the jury recommendation given by Tedder. The trial court recognized the importance of the jury recommendation of Tedder's standard, and specifically found that after weighing the aggravating and mitigating circumstances, no reasonable person could impose a life sentence. The evidence considered in the aggravation was the same as that presented in 1976. The court previously upheld 5 aggravating circumstances on this evidence in Ziegler versus State. That was in 1981. The trial judge found that there was now 4 aggravating circumstances, and he should have found cold, calculated, premeditated. Also, see point 1 on cross appeal. This court found that the mitigation established in 1976 was insufficient to override the aggravating circumstances, thus rejecting the jury recommendation of life imprisonment. Since Tedder was decided in 1975, this court was well aware of the standard to be applied in override cases. The mitigating evidence presented in 1989 was rebutted and contradicted to the extent its value was less than presented in 1976. In other words, the resentencing hearing had a negative impact on the weight of the mitigation, not only because intervening events showed Ziegler was manipulating people in prison to confess to his crimes, but also because the defense witnesses were totally discredited. Although the defense presented more witnesses quantitatively, their impact was quantitatively negative. The override is even more appropriate since mitigating evidence, which may have existed in 1976, is now discounted. The jury recommendation should be given less weight since the passage of time has demonstrated Ziegler's true character and that previous mitigating testimony was unreliable. Ziegler next argues that the trial court erred in finding no reasonable person could conclude that the mitigating circumstances outweigh the aggravating circumstances, although he argues that 12 jurors recommended life. There is nothing in the record to support this argument. In fact, the defense counsel argued that in sentencing, that specific jury vote was unknown. Okay. The trial judge order shows that he carefully considered the non-statutory mitigating circumstances, but that much of the evidence presented was either adverse, inconclusive, or irrelevant. For instance, The psychologist could not say that Ziegler would not premeditate further murders or be a threat to society. The friends that testified refused to acknowledge that 4 murder convictions and admitted that if Ziegler had committed the murders, they did not know him at all. The model prisoner testimony was rebutted by Ziegler's plan to have Danny Thomas confess to his crimes. Ziegler's concern for the Black community is discredited by the facts which show he manipulated 3 Black men and tried to pin the murders on them. He killed 1 Black man in the process and tried to shoot another, but his gun jammed. Although certain mitigating factors may be valid if supported by the evidence, the trial court found that very little non-statutory mitigation was valid and that which did exist was entitled to little weight. Finding or not finding a specific mitigating circumstances is within the trial court's domain, and reversal is not warranted simply because an appellant draws a different conclusion. And there's a bunch of cases stated right there, but we're not going to read those. A trial court has discretion in rejecting mitigating factors. Let's see. There is no requirement that a court must find anything in mitigation. The trial court determines the weight to be given any mitigating circumstances and whether the circumstances was even established. It is not within the reviewing court's province and revisits or reevaluates the evidence presented as to aggravating or mitigating circumstances. Hudson, Supra at 831, this finding should not be disturbed were supported by competent, substantial evidence. There's some more cases that they stated. The appellant argued that the deference paid to the jury recommendation of death was so great that the jury became de facto, if not de jure sentencers. This court rejected that argument, stating, "We are not persuaded that by the weight given to the jury's advisory recommendation, it is so heavy as to make it the de facto sentence. Notwithstanding the jury recommendation, whether it was for life imprisonment or death, the judge is required to make an independent determination based on the aggravating and mitigating factors." At Grossman 840, this is another case they're going to talk about. As stated in Grossman, this court has upheld jury overrides in many situations. The present case presents an interesting situation where the jury considered one set of mitigating circumstances and the resentencing judge another. Ziegler argues that the jury could have recommended a life sentence on the factors presented. However, they did not hear the evidence. In fact, if the jury had been aware of the negative effect of the resentencing hearing, they were more probably would have recommended death. Furthermore, this jury was not aware that they could consider contemporaneous murders as an aggravating circumstance, since that body of case law evolved after 1976. Okay, well, if that body of case law evolves after 1976, they could not even use that. What are you talking about? This is so full of shit. I'm sorry, said a bad word, but it is. All right, here we go. Neither was the jury aware that aggravating circumstances of cold, calculated, premeditated could be an aggravating circumstance, see point 1 on cross appeal. There was no reasonable basis to support the jury's recommendation. 2 different judges found that a jury override was required. No, it wasn't required. That's what they decided to do. It was not required. Although Ziegler argues that the resentencing judge was even more correct in overriding the jury recommendation than the first judge because additional mitigations had been presented, he ignores the fact that if the jury had heard the evidence presented at resentencing, they may have recommended death. The truth of the matter is that the available evidence presented at the resentencing was detrimental to Ziegler rather than helpful, and the second judge had no choice but to again impose a death sentence. Where there are so many aggravating circumstances and so few mitigating circumstances, this court has no choice but to affirm the death sentence. As previously stated, this court has upheld jury overrides where aggravating circumstances outweigh the mitigating circumstances. You know, it sounds like they just repeat the same thing over and over, doesn't it? There's a whole bunch of cases that they've stated right there. Although the advisory recommendation of the jury is to be accorded great weight, the ultimate decision on whether the death penalty should be imposed rests within the trial judge. Citations omitted. Death is presumed to be the proper penalty when one or more aggravating circumstances are found unless they are outweighed by one or more mitigating circumstances. Good God. No reasonable jury could have recommended life imprisonment under these circumstances. In Bonanno versus State and Bird versus State, the jury recommended the death penalty under similar circumstances. In Bonanno, the aggravating circumstances were, number 1, pecuniary gain, which means monetary gain, and heinous, atrocious, or cruel, cold, calculated, and premeditated, and or prior convictions of violent felonies. The Bonanno poisoned her husband. Oh boy. Bonanno poisoned her husband to collect insurance proceeds. On collateral review, this court found that the issue whether the trial court erred is rejecting mitigating circumstances was procedurally barred, and that even if the evidence of the defendant's impoverishment, upbringing, or dysfunctional psychological state had been presented, the mitigating would not would not outweigh the aggravating circumstances. In Bonanno versus Dudley, okay, they're stating that the aggravating circumstances in Byrd were number one, again, monetarily gained, number two, heinous, atrocious, or cruel, and number three, cold, calculated, premeditated. The mitigating circumstances was no significant history of criminal activity. The non-statutory mitigation was rejected. Byrd killed his wife in order to collect insurance proceeds. The jury recommended of death in these two cases demonstrates that the trial court followed established precedent in finding that no reasonable person could recommend a life imprisonment under these circumstances. Oh my God. The trial court should have also factored in the aggravating circumstances of cold, calculated, and premeditated, thus giving additional weight to the aggravating circumstances. See point 1 on cross appeal. Ziegler also argues that the jury was entitled to consider lingering or residual doubt as a mitigating factor. Since the jury recommended a life sentence, this argument is irrelevant. Further lingering or residual doubt is not a proper consideration. The Florida Supreme Court has consistently held that residual or lingering doubt is not appropriate in non-statutory mitigating circumstances. All right. Likewise, the United States Supreme Court has rejected residual doubt as a mitigating consideration. In Franklin versus Lamar, okay, this trial court ruled that guilt or innocence would not be relitigated in the penalty phase. Resentencing is not a retrial of the defendant's guilt or innocence. Okay. This court affirmed that the conviction of Ziegler versus State, noting that although there was certain inconsistencies in the evidence, Ziegler failed to show anything which purported to be reasonable hypothesis of innocence. Well, you did not test any DNA, okay? You never tested it by then. Yet he continues to relitigate the issues of guilt at every turn of the bend. The aggravating circumstances found by the trial judge were supported by the evidence. All right. Ziegler argues that the 4 aggravating circumstances found by the circuit court were not supported by the facts of record. The state submits that Ziegler is procedurally barred from challenging the validity of the aggravating factors which had previously been affirmed by this court. The sufficiency of the evidence to support these factors should have been challenged on direct appeal. In Ziegler versus State from 1981, this court found that the following aggravating circumstances were proven to the exclusion of any reasonable doubt. Number 1, the defendant created risk of death to many persons. And number 2, the murder of Charles Mays was committed to cover up the fact that he had earlier murdered his wife and in-laws and thus was committed for the purpose of avoiding and preventing arrest. Number 3, the murder of Eunice Ziegler was committed for monetary gain, collection of $500,000 in insurance benefits. And number 4, the murder of Charles Mays was committed furtherance of the defendant's plan to murder his wife for the money and to have it appear as she was killed by Charles Mays and others in a perpetration, sorry guys, and others of a robbery or breaking and entering. God. Okay. The murder of Charles Mays was especially heinous, atrocious, and evil. The court indicated that the murder of Eunice Ziegler was not especially heinous, atrocious, or evil. Well, then you would think that if that was the case, that he would get first degree on the atrocious and heinous and second degree on the non-atrocious and heinous. The evidence in support of the aggravating circumstances was exactly the same as the 1976 sentencing. The judge considered the entire transcript of the original trial, including the penalty phase and any physical evidence designated by the parties, items presented at the hearing, and those additional items introduced at the original trial, which he deemed necessary for complete review of the facts. The limited purpose for the resentencing hearing was for the defendant to present non-statutory mitigation. The aggravating circumstances found by the trial court after the resentencing hearing were, number 1, previous convictions of another capital felony. Number 2, the murder of Charles Mays was to avoid lawful arrest. Number 3, Charles Mays and Eunice Ziegler were committed for monetary gain. And number 4, the murder of Charles Mays was especially heinous, atrocious, or cruel. The judge found that the aggravating factor of a heinous, atrocious, or cruel did not apply to the murder of Eunice, since she was killed with a single unexpected gunshot. He did not find that there was a risk of death to many persons, as the original judge had. He found that he would have applied cold, calculated, and premeditated, except that he had previously ruled such application could be an ex post facto violation. So he couldn't even use that. The state submits that Ziegler's challenge to whether the heinous, atrocious, or cruel aggravating circumstances applies to Charles May is procedurally barred since this factor was affirmed on appeal under the same facts. Furthermore, the murder was heinous, atrocious, and cruel. Dr. Ruiz, the Orange County medical examiner, to whose qualifications the defense stipulated, testified during the proffer at trial that the cause of Charles May's death was blunt force trauma to the head, which caused cerebral lacerations and hemorrhages. Mr. Mays was also shot twice, once from the front and once from the back, but the bullet wounds did not kill him. The bullet which exited below the abdomen caused internal bleeding, but not enough bleeding to kill him. His right hand had dried abrasions on the dorsal side above the knuckles, indicating that he was trying to ward off his attacker. After the proffer regarding which photos would be introduced, Dr. Ruiz told the jury that Mr. Mays sustained 2 gunshot wounds at the cause of death was blunt force trauma to the head. Mr. Mays did not die from the gunshot wounds, which caused internal bleeding. The autopsy showed that there were at least 8 wounds evidence blunt force trauma. Oh gosh. The case cited by Ziegler are in opposites. Involved death by simple blow to the head. Okay, not eight whacks, just one. That's what they're saying. And it involved acts after the victim was unconscious, which this court has reportedly held do not support the aggravated circumstances of heinous, atrocious, or cruel. In C. Cochran versus State, and cases cited therein, Mr. Mays was shot twice and then bludgeoned to death, most probably with the crank found at his side. A crank. Okay. His face was crushed. Okay, trigger warning, guys. Just trigger warning right here. You're going to hear some pretty nasty stuff, but this is what happened. His face was crushed and fractured. The exhibits in the record on appeal show the extent of his injuries. Volume 1, Exhibits 33, 34, and 43. He was aware of his impending death and had defensive wounds on his hands. This court has upheld the application of heinous, atrocious, or cruel in similar situations, which is King versus State. Let's see. And there's a couple more that they have cited. Okay. Let's get past that. Okay. All right. Okay, these were heinous, atrocious, or cruel. Where a father turned in his car seat, looked in the back seat at the appellant, placed his hands upon a futile attempt at self-defense, and was shot. Okay, these are other cases where they're talking about how these people died, and they're trying to say, well, in this case, you did this. Okay, so we're going to go move past that because I don't want to read all that. Some of it's pretty detailed and it's pretty gross. All right. So let's go down. Ziegler next argues that the heinous, atrocious, or cruel aggravating circumstances applied arbitrarily and capriciously. This court previously found that Maynard versus Cartwright, in opposite to Florida's death penalty sentencing regarding the state's heinous, atrocious, and cruel aggravating factors, Smalley versus State and Brown versus State, this issue of arbitrary and capricious review by Supreme Court of Florida was put to rest in Proffitt versus Florida. All right. Florida's appellate construction holding the term to mean the consciousness or pitiless crime which is unnecessarily torturous to the victim proves sufficient guidance. Okay. The next argument presented in the death of Eunice Ziegler and Charles Mays were not committed for monetary gain. The state first asserts that this issue was decided on direct appeal and is procedurally barred. The evidence has not changed. This court found that the murder of Eunice Ziegler was to collect this insurance money. And for Charles, it was his plan to get away with the murder of his wife. Skip that right there. The evidence presented at resentencing actually supports this court's findings that Ziegler was surreptitiously acquiring insurance on his wife in order to prepare for her demise. Hardy Bond, to whom Ziegler had talked regarding insurance, was not notified that Ziegler purchased 2 policies and even went to dinner with Ziegler after the latter purchased policies from others. The 2 policies on Eunice's life were purchased within 2 or 3 months of her death. The testimony showed that $500,000 was an exceptionally high amount of coverage and more than he had on his life. The state shrinkage if Eunice died first was only $6,000 on the $500,000. The state shrinkage Ziegler refers to in his initial brief is that which would occur if Ziegler died first. Although Vaughn may have said $500,000 may not have been unreasonable, he thought the amount was excessive and prudent businessman would have purchased in a more advantageous manner. He would have recommended a $250,000 on Eunice. The family lawyer was not told about the policies even though he had discussed estate planning with Ziegler. This court has upheld the pecuniary gain aggravating factors where a party takes out insurance on another's life. In Bonanno versus State, this court found sufficient evidence to support the aggravating circumstances that the murder was committed for financial gains. Whereas as a result of her husband's death, Bonanno was entitled to receive life insurance proceeds and a veteran's benefit. Had Bonanno chosen to end the marriage by divorce, she would not have been entitled to any of this money. The defendant was the sole beneficiary of a $100,000 life insurance policy, although Byrd testified that he killed his wife because she refused his request for a divorce. This testimony was rejected by the court. Okay, it means they stated a few more. This court also found that the murder of Charles Mays was committed to cover up the fact that Ziegler had earlier murdered his wife and in-laws and thus committed the purpose for avoiding or preventing a lawful arrest. Ziegler's challenge to this factor is procedurally barred. Boy. Ziegler contends that they were the victim is not a law enforcement. Okay. Ziegler contends that were the victims is not a law enforcement officer, the dominant motive for this murder must be elimination of witnesses. Although this is an accurate statement of the cases cited, case law also shows that there were a victim either knows the defendant or could identify him. Application of the avoid arrest aggravating circumstances is proper. In Reed versus State, in 1990, he killed the victim to keep her from talking. And LaCroix versus State in 1988, he killed the witness to prevent her from reporting the murder of her husband. In Swofford versus State in 1988, a convenience store clerk was killed. And in Harmon versus State in Florida, victims knew the defendant. In Atkins versus State, to prevent a child from disclosing sex acts. Oh my God, you killed a child. Oh, that's terrible. Stephen versus State, he needed to eliminate the victims as possible identifying witnesses. Okay, we're going to skip past that. So there's a whole bunch of those cases they cited why the people killed the other person. None of the above cases involve law enforcement officers. In Swofford, this court summarized the applicable law on avoid arrest as follows. A motive to eliminate potential witnesses to a crime can provide the basis for this aggravating circumstances. Mendez versus State, and let's see, it is not necessary that an arrest be imminent at the time of the murder. Okay, there's a bunch that they stated. Although some decisions have approved findings of motive to eliminate witnesses based on admissions of the defendant. Boy, there's a lot of that they cited right there. Okay. Okay, let's get down and we get past those. Okay. Oh, there's a bunch of them. Okay. This court has also recognized that the arrest avoidance factor can be supported by circumstantial evidence through interference from the facts shown. In Swofford, Mays was not just a witness that was eliminated. Ziegler had drawn him into a plan to murder his wife and in-laws. Mays had knowledge which could implicate Ziegler in the murder. Once Mays entered the furniture store, it was obvious what had occurred. Ziegler killed Mays not only because he was a prospective witness to the murders, but because he wanted it to look like Mays had committed the murders. Ziegler killed Mays to keep himself from being implicated in the crimes. This is the very essence of the avoid arrest aggravating factor. Ziegler concedes that the trial court's finding of prior convictions of capital felony was proper, but argues that it is arbitrary and capricious to the base of death sentence on contemporaneous crimes. This court has repeatedly upheld prior convictions, aggravating factors in capital cases. Okay, while aggravating factors, we're almost done with this one. While aggravating factors must be proven beyond a reasonable doubt, evaluating the evidence is resolve factual conflicts or the trial judge's responsibility. When a trial judge, mindful of the application standards of proof, finds that an aggravating circumstance has been established, the finding should not be overturned unless there is a lack of competent substantial evidence to support. Okay. Even if one aggravating circumstances were stricken, it would not change the sentence. There's much more. Additionally, the cold, calculated, and premeditated aggravating circumstances should have been found, thus replacing any stricken factor and adding additional weight to the aggravating factors when none is stricken. Okay. The trial court considered the non-statutory mitigating evidence weighed that which was established against the aggravating circumstances and properly imposed a death sentence. Ziegler contends that the trial court failed to consider the non-statutory mitigating circumstances presented in resentencing. The trial court's order belies that the contention, since it expressly addresses each facet of the evidence presented. The states discredited, contradicted, or refuted each and every bit of the testimony offered by the defense. Although the witnesses knew Ziegler well, they admitted that they did not believe he had committed the murders. Although the judge ruled that the evidence of guilt or innocence would not be relitigated, the witnesses persisted in maintaining their belief in Ziegler's innocence. The friends that testified refused to acknowledge that 4 murder convictions and admitted that if Ziegler had committed those murders, they did not know him at all. How can the defense pretend the offers such witnesses' opinions as credible when their vision is jaded by their own blind perceptions of a man who brutally and without conscience killed his wife, her parents, and a friend? The witnesses testified that they were friends of Ziegler. The witnesses who did not have social dealings with Ziegler were Reverend Deshaw, who also testified that Ziegler was one of the 1,000 church members who he never really knew in depth, and Ocilla James. The record shows that this was the wife of a black bar owner who Ziegler, okay, remember the case you were talking about? Here comes that case. So let's go back here. What was this person's name? Okay, so Reverend Deshaw did not have social visits with Mr. Ziegler, but who also testified that Ziegler was one of one. Okay, that's that. Okay, Ocilla James, who was the record shows was the wife of a black bar owner who Ziegler helped move his bar. Even Ziegler's synopsis shows the potential bias of each witness, including a cousin business associate, a family lawyer, and friends and beneficiaries. Although he argues he was a model prisoner, his prison record was marked by the incident in which he tried to buy a confession from another inmate. He admitted that he was selling drugs in prison. The psychologist could not say that he would not premeditate further murders or be a threat to society. The trial court found that although the defense presented several friends who testified as to his good reputation and good deeds, most of these deeds were uncorroborated hearsay presented by those who would expect to support the defendant. The judge found the testimony of the best established Ziegler's character as no more good or compassionate than any other individual. The trial judge found that none of the testimony regarding church activities established unusual participations. The judge found that Ziegler had a good prison record and had adapted well to prison life, although the testimony revealed no propensity for a spontaneous violent conduct in the future. There was no evidence that the defendant would not engage in cold and calculated violence, conducted evidence by the murder. Damn. The court then made specific findings that no reasonable person could conclude that the mitigating circumstances would outweigh the aggravating circumstances. Finding or not finding a specific mitigating circumstances is within the trial court's domain and reveals is not warranted simply because an appellant draws a different conclusion. Okay, and they stated a bunch of different cases. A trial court has discretion in rejecting and mitigating factors. Okay, there is no requirement that a court must find anything in mitigation. So the trial court determines the weight to be given in any mitigating circumstances and whether the circumstances was even established. It is not within the reviewing court's province to revisit or reevaluate the evidence presented as to aggravating or mitigating circumstances. This finding should not be disturbed where supported by competent substantial evidence. In the footage, Ziegler alleges that the trial court shifted the burden of proof to the defendant. This argument has no merit. Point 1 on cross appeal. Damn. Ziegler filed a motion. Okay, so Ziegler filed a motion to preclude evidence and consideration of the aggravated circumstances of cold, calculated, and premeditated. He argued that the application of this aggravating factor violated his ex post facto prohibitions because the offenses for which Ziegler was convicted occurred more than 3.5 years before this aggravating circumstances was added to Florida's death penalty statute. All right, I'm going to stop right there. We're going to talk about that for a second. Now, I can see totally why he's saying that. It makes sense to me. Really, it does. He's saying, listen, all these other things, you tacked on to death penalties after my case was already settled. So why are you trying to add it now? Because if he was barred from using new circumstances to statutes that happened after his case, then you see what I'm saying? This is like a catch-22 or something. They're not even being fair to him. How can they? Damn, this case is crazy. Oh my God. All right, here we go. It's
Well, the whole
crazy.
thing is too, this man is deathly ill. I mean, he has
Right.
COPD, he's
Hmm.
on oxygen,
Right.
he is confined to a wheelchair, he is
Damn.
housed in the infirmary, needs round the clock monitoring, he is 6 feet tall and weighs 122 pounds. This man's life could end literally any day. He is
Right.
very, very, very ill. So, damn well the courts are like, why even bother?
Right. I don't know why they
You
haven't.
know,
Right. I'm going to finish reading this.
unfortunately, they look at this like, what's the point? This man's going to drop dead before we get anything figured out anyway, so why even worry about it?
Right.
I
Right.
mean, he's terminal. I mean, they haven't given him a time of, you have X amount of time to live, but he's not going to last much longer.
I hope from listening to all of this, all of this information that we're learning from this right here, to me, it's almost like, yes, I know they didn't test the DNA back then. They never tested well, they did test the DNA later, and it shows that there was not blood on him, etc. But see, before we knew that, what we did not know, because we did not read this first, is that he had left and went home. He could have changed clothes, he could have washed his hands, he could have done anything to get the evidence off of him. I'm starting to believe that he's actually guilty. What do you think?
Yeah, it's hard to say. It's really hard to say. I don't know. There's so much corruption. Anytime there's corruption, it really makes you wonder. You know what I mean?
Right, right, it does. But I mean,
Uh,
if you did not know all these facts right here, you would think, oh my God, he's an innocent man. They never tested the DNA. He was just ramrodding into this. But once you get to reading it
Yeah,
and getting the facts and hearing all this, you go, wait a minute.
yeah,
He
yeah,
left the scene. He then tried to get these other two guys to go in there, and he was going to kill them both, but the other guy wouldn't go in there, right? But he did get him to touch the light fence. Why would you take them out to shoot the guns unless you plan to plant this murder on them? Because their fingerprints would
yeah.
have been all over the guns.
But
See?
do you think 6 months ahead? I mean, I guess people can premeditate that far out. That just
Well,
to
yeah,
me
they can.
seems that just seems to me, if I was going to do something like that, I think I
Right.
wouldn't do it 6 months previous. I would do it much closer to the time, but I don't have a
But
criminal
think about
mind, so
Right. But think about this. If you're premeditating something, you can't just go out and buy the gun 2 days before and then go do it because that's
yeah,
obvious what you were doing. So, but if you
right.
bought them 6 months before, but I
Yeah.
mean, if you need to buy a hot gun, what is that about?
Yeah.
I mean, there's
Well,
just
yeah,
so
why
many
would he
different.
need to do that?
I know, buddy. Hey, buddy. My little dog's in here. He's looking at me like, what, mama? Anyway.
Yeah.
All right. All right. Let's finish
Like I
reading this.
said,
It's only a few more
it's so
pages. So,
easy
yeah.
to stand on one side and read it and say, okay, guilty, and then stand on
Right.
the other side and read it and say, okay, innocent.
Right.
It's so easy to do wherever your mindset is at the time,
I don't know, buddy.
which
No.
way you're gonna lean.
Right. It is wild. All right. I'm going to finish reading this. All right. Hang
But
on.
at
We
the
only
end
got
of
a few
the
more
day,
pages.
even if he is guilty, he hasn't had a fair shake at it. That's
Right.
the point of the point of all of this is seeing fairness in the judicial system. And this has not been fair to the man.
I agree. Okay. He argued that the application of this aggravating factor violated the ex post facto prohibition because these offenses for which they are convicted occurred more than 3.5 years before this aggravating circumstance was added to their death penalty. Although Ziegler recognized that his court upheld retroactive applications of the code calculating aggravating factors, he argued that this case was inopposite because it was not a resentencing case and it became preceded, and then it names a bunch of different cases. Ziegler also argued that although, let me put my baby dog down. Oh, oh, there. He goes, although Ziegler recognized that this court upheld retroactive applications of the Cole calculated aggravating factors, he argues that the case was inopposite because it was not a resentencing case because it preceded Miller versus Florida. Ziegler also argued that although this court rejected his argument in Justice versus State, it did not it did so in reliance of Dover versus State, which did not address the applicability of ex post facto to the cold, calculated aggravating factors. This trial court granted Ziegler's motion, reasoning that if his decisions were made with an additional aggravating circumstances not available for the jury to consider, it would diminish the effect of the adversary verdict. Diminish the effects of the adversary verdict. I'm getting tongue tied. The trial judge also stated that this court recognizes the principle of the stare decisis and is not determining the constitutionality of applying Florida state, blah, blah, there's the statute, to a crime committed before the enactment of this provision. Although in light of Miller versus Florida from 1987 and Stano versus Duggar from 1988, it would encourage reconsideration of this issue when appropriate. This court has considered and finds that the application of Florida Statute 921.141 to the particular facts of this case would be unconstitutional as a violation of the proscription against ex facto application of laws. I don't know why they have to use such big words. It's really crazy. Why can't you just use this in standard language? Like for regular people? Anyway.
Words are hard sometimes. Words are very hard sometimes.
In order for a criminal or penal law to be ex post facto, it must be retrospective, applying to events occurring before its enactment, and must disadvantage the offender affected by it. No ex post facto violation occurs when the change effected is merely a procedural and does not increase the punishment or change the ingredients of the offense or the ultimate facts necessary to establish guilt. The court held that the application of revised sentencing guidelines to a defendant whose crimes occurred before their effective dates violates the ex post facto clause because, although the law provided for continuous review of the guidelines, it did not warn the defendant of the specific punishment prescribed for his crimes. The defendant was found to have been disadvantaged by the increase in the presumptive sentence because, although the trial judge could have imposed the same sentence under the old guidelines, by departing from the presumptive sentence range then in existence, the revised law foreclosed the defendant's ability to challenge the sentence on review because it was within the new presumptive range. The revised sentencing guidelines were not merely a procedural change in the law. The decision in Miller is not retroactive change in the law, as Miller does not overrule but follows the lines of reasoning set forth in Dobert versus Florida. The court in Dobert recognized that a criminal does not have the right to be tried in all respects by the law in force when the when the charge was committed. It found that the change in law from the old Florida statute, which provides that a person convicted of a capital felony was to be punished by death unless mercy was recommended by the majority of the jury, to the new statute in which the jury considered aggravating and mitigating circumstances and rendered an advisory decision on the death penalty, was procedural and afforded a significantly more safeguards to the defendant than did the old statute. So the new statute did not work onerously applications of ex post facto change in law. The ex post facto clause looks to the standard of punishments prescribed by statutes rather than to the sentence actually imposed, what is forbidden is the application of any new punitive measures to a crime already consummated to the determined material disadvantage of the wrongdoer. In Miller, the defendant received an unreviewable increase in punishment, which was involved in Dobert, which was a standard of punishment which met the provisions of the ex post facto clause. The decisions below is an anomaly and interrogation of Dobert, in which the entire statutory scheme was considered. Okay. At the time of the commission of the offense in Dobert, there were no statutory aggravating factors. It is clear from Dobert that there were enumerations of the same acts, nothing new since the facts of the crime are always before the jury, and mercy is hardly precluded in sentencing considerations. Okay, now, if the legislature had added an entirely new factor as an aggravating circumstance, then the retroactive consideration may violate the prohibition against an ex post facto laws, as set forth in Weaver versus Graham. However, the addition by the legislature of paragraph I to section 921.1415 in fact only reiterates in part which is already present in the elements of a premeditated murder with which petitioner was charged and which the evidence clearly supports. Although consideration of aggravating factors must be limited to those set forth in the statutes, the elements of the specific offense charge are must and be inherently part of the circumstances taken into consideration when imposing a sentence in capital cases as well as other criminal cases. Paragraph I only adds to the statute that requirement that in order to consider the elements of a premeditated murder as an aggravating circumstance, the premeditation must have been cold, calculated, and without any pretense or moral legal justification. Paragraph I, in effect, adds nothing new to the elements of the crimes for which petitioner stands adjudicated, but rather adds limitation to those elements for use in aggravation, limitations which ensure the benefit of the defendant. The court has previously rejected Ziegler's claims. Okay. Although the trial court cited Stano versus Duggar, U.S. Middle District Court case number 88-425-CIB-ORL-19 to support his rulings. Not only is this case a decision of intermediate federal court, but it is also a rehearing of the 11th Circuit Court of Appeals. Stano versus Duggar, being the decision of the intermediate federal court, provides no basis for relief under Witt versus State. The 11th Circuit Court has previously found that the subsection 5I, allowing the sentencing court to find an aggravating circumstance that the homicide was committed in cold, calculated, and premeditated manner without any pretense of moral or legal justification, generally narrowed the class of persons eligible for the death penalty. Harick versus Duggar, and they cited that one. Since the mere enumeration of his aggravating factor does not alter the substance of the sentencing law to the determinant of the capital offenders, there is no ex post facto violations. The quantum of punishment, i.e. life in prison or death, is unchanged. Conclusion. Based on the above and foregoing arguments, an authoritative appellee respectfully requests that this court affirm the order of the trial court imposing the death penalty and reverse the decision of the trial court finding the application of the cold, calculated, premeditated aggravating factor, Thomas Ziegler, to be ex post facto application. So they read the whole thing. Jeez. Oh, that was a lot to read. Anyway, so there you go. That is that whole 48-page document about this case. So after finding all of that, I mean, I just really I don't know. I was not there. I mean, I can only go off of what we've read, what we've seen, and it seems to me like there is a possibility that he really might be guilty. Why would he need to coerce somebody else in prison to take the blame? Why would he even dream that up? That sounds so strange. I mean, all of the things he's done after the fact just makes me really reconsider what I said first. Because at first, I thought, oh my God, but no, something's definitely wrong here. And I don't know I kind of feel like at first I thought Mays was going to be the one who was robbing him. But then after reading all this, it seems to me like he was just using Mays to set up what happened for Mays to take the fall. Now, from what I understand, I believe Mays is a person of color. So based on what we found out from the appeal right there, from the statements. So, damn, this is crazy. Maybe because they're never going to set a death date now. He's 80 years old. They're not going to do that. I mean, it would be cruel and unusual punishment to do it now. Think about that. I mean, he's golly, Sprinkle. I don't know, man. This case is. I never expected. See, I don't always pre-read these things. I find things I want to talk about, and then I go in cold, just like y'all do, so I can have the same response that you have about. Oh my God, Okay, I'm hearing noise. Okay.
I know my headphones just popped off, so they
okay.
disconnect for a while. I'm gonna mute it so you don't hear it.
Okay. Well, no, I want you to talk about what you think after hearing all of that, since we're through reading the 48-page document. I'll just mute while you talk. Okay.
Yeah, I'm kind of with you. It kind of tends me to believe that maybe he was guilty after all. And like I said, even if he is guilty, he should have had a fair shake at it, and he didn't. Let's convict him the proper way. Oh no, where'd she go? Are you there? Oh no. I just,
There. All
it's
right, I'm fixed. All right. No, my
okay.
little finger pointer thing wouldn't work right to unmute myself after I muted myself. So now I know don't do that. But anyway, no, I mean he didn't really have a fair trial, but he does appear to be guilty. Now,
There's a lot of things that are definitely leaning that way.
yeah. I mean, knowing that they never tested the DNA, and then when they did test the DNA, it was not on anything. But because he went home, he had a chance to change clothes, wash his hands, all that. He washed away the evidence.
Yeah.
Now I mean, did he shoot himself when he got back to the
But what
store?
if he leaves some clothing that had some blood on it? Wouldn't you think that he would remove all blood from him? Don't you think he would remove everything?
Well, not well. I mean, you would think that, but I mean, who shot him? Mays is already deceased. He's already shot Mays twice, but Mays didn't die. So then he bludgeoned him to death. So who shot Mr. Ziegler? Did he shoot himself? Did Mays shoot him? What happened there?
Yeah,
Hmm.
it's a hard one.
It is a hard one. So, golly, that is just wild, just wild. So I guess we've been on here 2 hours and 30 minutes. I did not know we were going to talk about it that long, but yeah, I mean, we're going to have to watch and see. I think he's probably just going to die in prison. I think because on the 27th, the judge just said no. And he can't file anything else. That's it, it's over. I believe it was March the 27th, no, March the 7th. Hang on. Okay, let me look at this right here. This is the final thing that happened, March 7th in the Ziegler case. Judge came down with, hang on, I'll get this final thing right here. And I think he can't file anything else. That's it, it's over. The hearing where the court addressed the newest filings and the decades long, yeah, that's the one, okay. The judge said this case was deeply troubling and acknowledged the extraordinary length of time that Ziegler had spent on death row and stated that the court was not blind to the concerns raised by the DNA evidence. He also emphasized that this case has a long, complicated procedural history. The court is bound by the legal standards for successive post-conviction relief. Even troubling evidence does not automatically meet the statutory threshold for reopening the case. And the key line that everyone quotes is, this court is not unsympathetic to the concerns raised by the law limits what this court does. So that is in plain language what came out on March the 7th. The judge says that nothing. The judge, I mean, he said nothing, basically. There's nothing more they're going to do.
Yeah. I think they can take it to the Supreme Court, but that's going to take a really long time.
No, he's had all the appeals he can have.
Oh, really?
Okay, I'm hearing that noise.
Take
Yeah.
this last decision to the Supreme Court?
Now he's done all that. This was his final. Yeah.
Yeah, he doesn't have long in this world anyway. Unfortunately.
Yeah. I mean, yeah, at 80.
And in the health that he's in, you know.
Damn. Well, okay. I guess we will end this today with, I'm just gonna let's just say like, share, and subscribe. Please pass this along to your friends. Maybe they want to know something about the person that's been on death row the longest in the United States of America. I mean, we've listened to it all. I mean, we did a deep dive into Thomas Ziegler's case.
Yeah, and if you all have any suggestions on something you might like us to cover too, please leave it in the comments.
I'm going to go ahead and put this live into people and blogs, but there's also a section of YouTube for people who, activists. I'm going to put it in there too, because there are people who are totally against the death penalty, period. And, we know there are.
Right.
And so I think that people against the death penalty may want to take a look at this and say, my God, not everybody knows about this case. It's not one of those high profile cases that's in the news all the time.
No.
I only knew about it because I was just looking around and it said the person's been on death row the longest. I thought, oh God, that's something pretty interesting. But I've not seen it in the news. So
yeah. No, I have even when the final decision was brought down, I never saw anything.
All right. So with that, we're going to say good day, good night, goodbye. We'll see you later. Y'all be careful out there. Take care of yourselves, and we always leave with,
Hug your babies.
that's right. Life is short, and our time with them is even shorter. And the reason why I say that is because we know our children grow up and they go off to college and then they don't move back home. See, they start their life. And so that being able to just walk up and hug them anytime you want to, that's over. Anyway, I'm hearing that noise. Ugh. All right. Anyway, so with that, we're going to say good night. We'll see you later. I'm sure we'll see you in somebody's chat later on tonight somewhere. And tomorrow, I don't know what I'm going to do tomorrow. Yes, I do know what I'm doing tomorrow. Oh, I don't know. I'll advertise it. I'll put it back out there later. But anyway, y'all take care. See you later. Please share, like, and subscribe. Bye, guys.
Bye, everybody.